The time is about 1:10 p.m., and I would ask the clerk to please call the roll.
Good afternoon, everyone. As a reminder to all in attendance, this meeting is being recorded and live streamed on the county's YouTube page. Also, as a reminder to all meeting attendees seeking parking validation for today's meeting, please be sure to scan the QR code located on the back table near the chamber's entrance to claim your discount. If you do not already have a Metropolis account, you will need your license plate number to set up the account in advance of receiving your discount. Please be sure to complete this prior to the end of today's meeting, as the QR code will be removed at the conclusion of the meeting. Calling the roll, Mr. Sweeney.
Present.
Mr. Castleberry.
Here.
Mr. Gallagher. Mr. Schlepper.
Here.
Ms. Conwell.
Present.
Mr. Jones. Here. Ms. Turner. Ms. Turner is absent at the moment. Mr. Hauser.
Here.
Ms. Simon is absent at the moment. Okay. Mr. Kelly.
Here.
Council President Miller.
Here.
You have a quorum.
Thank you very much. And the next item on the agenda is public comment. Do we have anybody signed in?
Daryl Houston. Mr. Houston, if you could make sure that green button is lit.
Okay.
Thank you.
My name is Daryl Houston. I'm a resident of Bedford Heights. Today, I just wanted to give you guys something to think about and consider as you sit here and listen to some of the issues. And I hope you guys cast a strong vote towards what's right and what's wrong today. I, as a resident, do believe that we do need elected sheriff. And the reason why I believe we need an elected sheriff is because the sheriff represents the community. And it's the community, the majority rules. And if he has to answer to the community versus answer to one person, then that seems like it would serve a better service to me, okay? Now, the other issue of a county prosecutor wanting to be the total overseer of the county building as well, to Mr. O'Malley, with due respect, there's a lot of things going on over in your office right now that you probably should be paying attention to, okay? There's a lot going on in Chris Ronay's building that he should be paying attention to. As a taxpayer, it is a shame that we have to sit here and watch people have personal vendettas towards each other versus doing what they were elected to do, because O'Malley is elected, so is Chris Ronay. And we elected both of these parties to go in here and represent this community as a whole. And right now, with what we're seeing as residents and taxpayers, I don't believe that neither party is paying attention to what's going on in Calhoun County. Calhoun County is in trouble. And we elected leaders to get us out this trouble, not to have personal vendettas or trying to rule something, right? We ain't into that no more. We want accountability in this community, okay? That's what elections are for. Thank you.
Mr. President, let the record reflect that Ms. Turner is in attendance. Next is Brenda Bickerstaff.
Good afternoon, everybody. I'm here as a resident today.
Ms. Bickerstaff, if you could state your name for the record, please.
Sorry, Brenda Vernay Bickerstaff. I'm here as a resident today, and I want a sheriff that knows how to be a sheriff without having a consent decree over his head. When I first met Bertel, my son's cat got hit by a car. I was speeding to get the cat to the doctor. Unfortunately, I was pulled over, and Mr. Bertel asked me, why were you driving so fast? And he saw my son in the back seat crying with his cat, so he gave us an escort. But unfortunately, my son's cat passed away. But a sheriff like that is a sheriff what we need, and I want our sheriff to be elected. No disrespect to none of you on this panel, but what you may pick may not be what I want. So I want our democracy back. I want my democracy back. And I want you guys to vote. Please vote to put it on the ballot so we can decide. We're the people. Now, I want to caution you. If you vote against it, Don't be surprised if you don't see a ballot initiative through this county. So I'm just putting it out there. This is not a threat. This is not a promise. This is just telling you it can happen because we are the people. I'm from this county. I was born and raised in this county. My parents is from this county. When my dad was a cop, he was a cop in this county. He was a Cleveland police officer. All my sisters and brothers went to Cleveland Public Schools. One of my sisters is a lawyer. One is a retired police officer from Pittsburgh. So we got investment roots in this county. And we want an elected sheriff. I want to be able to go and talk to my sheriff because I voted for him. Not because somebody appointed and they're going to tell me what I need to do and say to my sheriff. And that's what I want to see. As far as the county prosecutor's office is concerned, they got too much power. And I think if they focus on that office and make sure we don't have wrongful convictions and people being wrongfully arrested, they'll be in good shape.
Jennifer Johnson.
Good afternoon. Council President Miller and members of council.
Ms. Johnson? Oh,
Yes,
thank you.
My name is Jennifer Johnson. I got you. And I'm the Executive Director of Canopy Child Advocacy Center. I'm here again today to express my support for the Health and Human Services Levy. 1 in 7 children experience abuse before their 18th birthday. 1 in 7. There's more than 7 of you up here. That means 1 of you may have or could have. And in Cuyahoga County, there's nearly 20,000 reports of suspected child abuse that are made every year. Behind every one of those reports is a child. And for more than 900 of those children last year, Canopy was part of that answer. That is almost twice the number of kids we served the year before. And that is because of the support we received from the Health and Human Services Levy. At Canopy, a child enters one safe, child-focused place and they tell their story once to a trained forensic interviewer instead of repeating potentially the worst thing that's happened to them to a stranger and another stranger and another stranger. Medical professionals, law enforcement, children's services, prosecutors, therapists, and advocates all work together. The child and family are not left to navigate those systems alone. HHS funding makes that coordinated response possible for Canopy and for many of the partners that work alongside us. I'm not going to pretend that the passage of this levy is going to be easy. Even with it, hard decisions still lie ahead. But without it, painful choices become catastrophic ones for children and families in Cuyahoga County. On behalf of the children who can't come before you themselves and all of Canopy and our staff and our partners, I respectfully ask the council move forward with the Health and Human Services Levy support. Thank you.
Kenneth Griffin.
Good afternoon. My name is Kenneth DeFrance Devo Griffin. How y'all doing today? Hey, can you tell how excited I am to be here? What's up, Mr. House? How you doing, bro? I'm here because 2 years ago, I stepped in this room, and I told you guys I just did 33 years, 7 months. And there was a gentleman in the audience when I was telling my story about me not being employed, that they was turning me around everywhere I went. I couldn't get a job because I had a murder case. But in prison, they told me they hire felons. But when I got out here, it was a different story. But a gentleman in this same audience that was here 2 years ago approached me at the elevator, and he said, give me a call. I got something for you. I called him. He introduced me to a program called CEO. I went to that program. I graduated from that program, and I took off running. I have my own business, men like me. I hire guys coming out of prison. I'm doing real good for myself right now. My secretary right now is summoning up a letter to the parole board on my progress because I thank those 7 people that gave me a chance. I thank brothers like Mr. Houston that gave me a chance. When I came home, I didn't have no money. I didn't have no job. He gave me a brand new vet. He let me come wash cars at his car wash. He put money in my pocket. He showed me a better way than my other friends wanted to show me. And that's the route I went. And the reason I'm here today is to say thank you to you guys. But I also want to say, let's put this money in our community to fund guys like me, to hire guys that's coming out of prison. I don't know what you guys doing with your money. I don't know. Hey, I'm not like a lot of guys. I'm not finna come up here and tell you how to do your job. That ain't me. I just need help still. And I know you guys can make it happen. Peace.
Antoine Finley.
Hello, how y'all doing? My name is Antoine Finley. I'm the founder of the Rebuild Project, LLC. I'm not here to argue with how our neighborhood should be policed, but I think mental health and giving to our children, pouring back into them is a major priority, and organizations like us need help. So I wanted to come here, introduce myself, and make some build some bridges to impact my neighborhood and our children. So, and like I say, I help them mentally while I'm here, but I feel like it's more COs versus LSIWs and people that can mentally help them after the program, because they're still going home dealing with violence and stresses and trauma. So, yeah. That's it. Nice to meet y'all.
That concludes the public comment portion for today's meeting.
Thank you very much. We now come to our, the first of our three legislative matters for the day, referred to committee, and to conduct this portion of the meeting, I'm going to turn the gavel over to our Chairman of Operations Committee, Councilman Schlepper.
Thank you, Council President. Okay, we're going to be discussing one of our charter amendments today. Obviously, this has been a topic of conversation for quite some time. So we're going to get started. Madam Clerk, if you will read item 182 into the record for us, please.
Resolution 2026-0182, providing for the submission to the electors of the County of Cuyahoga an amendment to Sections 4.01 and 5.06 of the county charter to delineate powers and duties of the prosecuting attorney and the director of law.
All right, is there someone to speak to this issue from the administration's team?
Mr. Chair, yes. Eric Janis, Chief of Staff, if I may. Members of council, 8 weeks ago, the administration proposed a charter change to clarify the role of the law department and provide certainty for the employees who do perform legal work on behalf of both the administration and you, the county council. We all rely on this legal team to conduct the necessary business of the county on behalf of our residents. Over the past several weeks, we have worked closely with the county prosecutor and his team to develop mutually acceptable language. The substitute language before you today reflects significant concessions from the administration that will impact county business, but we also believe it captures the fundamental intent behind our original amendment, and there are two. First, it formally recognizes and preserves the legal work of the law department that the law department performs and has performed for more than a decade. And second, it ensures that this work will remain with the law department, regardless of changes in elected officials. Although full consensus with the county prosecutor was ultimately not achieved, both sides made substantial good faith efforts throughout the process, and the administration thanks the prosecutor's office for those efforts. In the documents you have been provided, you will see the revised language, which was largely developed in collaboration with the prosecutor's office, except for the items in red where we were unable to reach agreement. We ask for you to consider, and we hope you will accept this language. I'm now going to turn it over to the County Law Director, Rick Maniloff, to walk through those three proposed changes.
Mr. Chairman, any chance we can ask the Chief of Staff questions? Thank you very much. I appreciate your comments, Chief of Staff. First and foremost, I want to just state how great our coworkers are in the law department. And after I talked to one of my coworkers, the stress that they have on this topic is very evident. Us working through this, and they do a great job. So that's my forefront of my brain. And you mentioned that you introduced this a while ago, right? Did you talk to the prosecutor before you introduced it?
Mr. Chair, to the council member, no, we did not. And I think that has been a topic of concern that the prosecutor has previously brought up. And that's why we try to work in good faith with them after it was introduced.
We'll keep going there for a second. Just for the record, my understanding of this all started with a report or opinion of the AG's office. And in the AG's office, did it say, if we want to correct this memorandum of understanding, a charter change would be a way to do it?
Mr. Chair, not being an attorney, I don't want to speak exactly to what's in there, but that's my understanding that that was a recommended remedy from the Attorney General.
Yes, and that's mine as well. So just my own thought to my colleagues is independently working and introducing something. The prosecutor could introduce something. You just chose to do it without any communication, which is a frustration for me. I can go through the whole participation that I had, even Thursday, getting super close with one comment, 11 words, talking with the prosecutor, talking with the lead negotiator on the administrative side, and it just fell apart. And for me to get this piece of paper, to be asked to vote on it today is minimally disrespectful. And I just wanted to share those thoughts. I could have took the floor a little longer, but you got my message. So thank you, Mr. Chairman, for allowing me to do that.
Mr. Chair? I think it's important to get another perspective on the situation at hand. I've been integrally involved in the negotiations starting last week, hours on both sides. And before you is a substitute of the executive's proposal, which captures, and we're going to hear hopefully from everybody, from the prosecutor to the law director, captures what I believe to be an appropriate, reasonable compromise that will enable both sides to continue on as they have been for the last 16 years, basically. And I understand that it's not perfect. I understand it can't be perfect, but I believe as a charter amendment, it's going to provide direction and stability and enable both parties, both sides at this point, to coexist and hopefully be able to work together. So that's what's before you, but that's just a prelim, and I'm sure we're going to hear from both sides. And by the way, I understand the concern from the law department that somehow, you know, at some point, someday, somebody can snatch powers back. But I think right now we have nothing, and it's important to look at that reality.
Mr. Law Director.
Thank you, Mr. Chair. I think what I will do with your permission and approval is just to walk through each of these sections and describe very briefly kind of what's in them, and also, as Mr. Janus has said, point out language issues that remain, and the importance of those language issues. So, I guess if everyone has the proposed substitute in front of them, I believe that was handed out. I will start by walking through this with the overview comment, as has been expressed, that the issues that we have discussed and debated and researched, got together on, have been important and have been difficult. This has been extraordinarily hard on everyone involved, and there's a question mark whether there was enough time to work out all of the remaining language issues and wrinkles that needed to be worked out, but it wasn't for lack of effort on everyone's part. And I want to thank those on both sides of the table for all of their extraordinarily diligent efforts in trying to reach an agreement on a charter amendment that clearly, as best we can, delineates the powers and duties of the law department and the prosecutor's office. So with that, there's an overview comment. I would start with subsection A, and A basically describes the what. B is the who, A is the what. So what are the core duties of the law department? That has been, as has been stated, that we are trying to take a snapshot of and write into the charter, because that's what we have been doing, as Councilwoman Simon said, for the last 16 years. We're taking a snapshot of it and we're putting it into the charter. The language that you see in front of you, aside from the red language, is language that has been agreed to. We got a draft from the prosecutor's office last Friday afternoon, and spent yesterday all day into the night discussing it and grappling with it. And there's one issue that's highlighted in red. We had proposed on July 22nd that we include employment matters in the list of core issues of what we do, and we still don't have yet an agreement on that. That is a big part of what we do. The council itself, when it created the law department under section 202.05 of the county code, established that the general division of the law department shall contain the following sections: A, labor and employment. And so we do a lot of employment law, and so in that light, we believe that it is important to say that. That is a snapshot of what we do significantly. So as to A, as to the what are the core duties right now and functions of the law department? Well, there you have it, and we have an agreement on it. But for language relating to employment matters that we still need to try to work through. But again, to summarize that statement, we believe that the law department, I'm speaking for the law department, it's important. It's if we're taking a snapshot of what we're doing, this is in there. Next, as to the who, so the A was the what, and B is the who. Who are we, the law department, giving opinions and advice to? You know, those particular sections that you see listed there were, again, heavily negotiated over time. And I would point out 3 policy issues that ultimately council is the policy maker here. So I'll point out 3 policy issues that represent as essentially concessions by the county executive who sponsored this charter amendment. Number 1, you will not see any reference to the Charter Review Commission in the who. Again, as a policy matter, that's up to you guys to decide who will represent the Charter Review Commission, but it's not in there, and it represents a concession on the part of the county executive. The history there, again, if we're taking a snapshot of what we're actually doing, the law department has represented the Charter Review Commission the last 2 times that the Charter Review Commission met. So that's policy issue number 1, but that's not, you don't see that in red. You don't see that added back in. So that represents a concession there. Policy issue number 2 would be there's no reference to Article 16 of the charter. There's no reference specifically to the sheriff. So that's policy issue number 2 for you. Policy issue number 3, the Inspector General. There was a lot of discussion about that. And in the 2013 agreement approved by council, there was a whole section that I shared with you 2 weeks ago on the Inspector General and essentially having the law department, basically giving the Inspector General the option to go to the law department. But if there's a conflict, then the Inspector General has to go to the prosecutor. So there was a whole section in the 2013 agreement on that. That has been taken out. So you'll see no red line there trying to add back in the Inspector General, the Sheriff specifically, or the Charter Review Commission. You will see in red in B, and I'll highlight it, they're responsible to. We've gone back and forth on that. This is a hard one. The language that we saw last Friday afternoon from the prosecutor's office did not have the language of responsible to. It had other language that said whose chief executive officers serve at the pleasure of the county executive or county council. And so that's language that the responsible to language, we proposed that no later than July 22nd, and we just haven't reached an agreement on that particular language. The language itself was taken from the 2013 charter amendments that council itself put together, and I presented on that and showed it to everybody 2 weeks ago. So that's where that language came from. So that's highlighted in red is a continuing point of language disagreement. Now C, again, just two more to walk through. C is essentially, there's a policy issue here. There's a concession baked into C that basically provides that the county executive, county council, and other officers and departments can seek or obtain advice and representation from the prosecuting attorney. So that opens the door there very clearly and explicitly for folks to go to the prosecutor's office for legal advice on things. So again, that's a point of concession there. You don't see any red in that section. Section D, this was the hardest section that we've struggled with from the beginning of our conversations. Gone back and forth on it as late as last night. We're still trying to figure out how we're going to thread the needle here. What's the needle we're trying to thread? And trying to protect the core duties and functions of the law department, while at the same time preserving the prosecutor's stated goal of not relinquishing powers that he has under general law. And so what you see there is, in proposals, there's been a lot of language proposals, and one of the latest proposals I think that we made in mid-July was to just take out that first sentence, which is the problematic sentence from the perspective of the law department. And that would open the door for potentially a future prosecutor to assert powers over those core functions as listed in subsection A, and basically undercut that which is stated in subsection A. And so what you see in red, in my judgment, ought not be a controversial clause. It is simply repetitive of what you see in A. It says provided that, so section 5.06, the whole thing, which would include A, shall not in any way limit the powers and duties of the prosecuting attorney as set forth in 4.01 of the charter. That's the one or two sentences that pertains to the prosecutor's powers and duties already, and general law. Provided that the law director shall provide primary representation on the matters set forth in 5.06A. So it's restating for clarity, and because that first sentence continues to remain in the prosecutor's draft as of last Friday afternoon, we believe that clause in red is important to make it clear that the law department remains remains the primary legal representative on those matters listed in numbers 1 through 4. The rest, you will see a concession made along the way that the next sentence of subsection D talks about the prosecuting attorney and his or sole discretion through joint application with the county executive may refer matters to the director of law. We attempted to include in that sentence an either-or scenario where that's one way that the matters may be referred to the director of law as through that process involving the judicial branch. We had suggested an or clause following up on the Yost opinion, quite frankly. That said, if the prosecutor and the director of law, with the approval of council, with the approval of the legislative branch, and the signing off on by the county executive, if everybody agrees to that allocation, then that's another way to go. So we had proposed that. In either case, the county prosecutor would be a gatekeeper because the county prosecutor would have to sign off on such an agreement. And again, the whole reason for requesting that to be put in would be to satisfy what Yost had said, that the 2013 agreement was invalid in his judgment, Yost's judgment, because the charter didn't have that kind of a hook. And so we were proposing that kind of a hook. And it thus represents a concession that's not in there, that there is one way to go about referring matters to the director of law outside of these charter provisions. I'm just pointing out, the concessions that have been made along the way. Another concession, of course, and I mentioned this last time around, 2 weeks ago, is you will see no reference to the hiring of outside counsel by the law director. That was included in the council's 2013 charter amendment. It was included initially in the county executive's proposed charter amendment, and that has been taken out, as you see. And another, perhaps final point to make in subsection D, as I finalize walking through this, is language pertaining to civil litigation. Civil litigation at one point was housed within the Department of Law. There was a 2017 memorandum of understanding that was entered into that changed that, and civil litigation has now been housed, since then, has been housed in the Cuyahoga County Prosecutor's Office. And this last sentence that you see goes beyond saying that the prosecutor's office shall be the primary legal representative with respect to civil litigation. It says that's it, that in no event shall the director of law basically participate in civil litigation. So you'll see a difference in language there, and that represents as well a concession, because that was not included also in the 2003, quite the opposite, was included in the 2013 charter amendment proposed by council. So I wanted to point out along the way here some of the points of language disagreement. As you will see, there is a lot of agreement. There are a few points of disagreement. A lot of effort and hard work has gone into this, and concessions were made along the way, I would say, by both parties at the table. So I guess at this point, I would just thank everyone involved again in the process, and open it up for any questions, I guess, of a technical nature. I'm the lawyer geek, and so I'm happy to answer questions of a technical nature, for sure. Thank you for your time.
Thank you, Mr. Law Director. I was actually going to ask if the prosecutor would like to come up and speak to some of his pieces at this point, and then we have a little bit of clarity surrounding where we are on both ends of the spectrum.
Sure.
Thank you,
Good afternoon.
Mr. Prosecutor.
I would like to say that, what we started off after this legislation was introduced without any input from us. we sat down and sincerely tried to work towards a constructive resolution towards this issue, because we felt that is in the best interest of the people that we all represent. What happened that day was disrespectful to my office, to myself as an office holder, and generally to the people of Cuyahoga County, that people in elected office choose to create divides instead of choosing to create bridges. And as Councilwoman Simon has indicated and Councilman Sweeney has indicated, we have been working together for hours and hours and hours over the last several weeks with additions and changes and additions and changes and additions and changes. And everything was down to a couple words last Thursday, Friday. Some of the stuff that they're changing now was already agreed to that wasn't going to be in there. But about 1:30 on Friday, there was radio silence. We sent them our last changes, which were for a few words. We conceded some subject, and there was a few words changed, and then we heard nothing. We didn't hear anything Friday afternoon. We didn't hear anything Saturday. We didn't hear anything Sunday. We didn't hear anything Monday. Till about 6 o'clock on Monday night, I sent a text to Brendan Doyle, and I said, the silence is deafening. How our government got into a situation, and even as of this morning, Councilwoman Simon was pushing, because I thought, and I think Councilwoman Simon thought, that what we had proposed last Friday was going to be acceptable. And there was silence. And again, what we saw today was at about 1:45, I got a phone call. It says, I hear the administration is introducing their own version. No running it by us after weeks of collaboration, no dialogue, no back and forth. Here's what we're putting forth without even the courtesy to allow us to see it until it was just handed to me by Mike King. The citizens of Cuyahoga County deserve better. You all deserve better, because that has placed you in the position of having to deal with something that, quite frankly, could have been resolved, but now isn't. And that's not your fault, not Councilwoman Simon's fault. She put hours into this, not my fault. We called, we texted, and we got nothing. But the same mentality, the same moral bankruptcy that introduced this without our input is the same mentality that thought, well, we're going to introduce an amended version without running it by them too. Because they must think, I can only assume, that there's people sitting in front of me who are cut from that same cloth. I don't believe that's true. I believe everybody up here knows right from wrong and what's right for the people that we all represent. And that gentleman there said, you know, why do those two fight? I don't know why this happens. We were getting along good. But it's the compass that we all have inside. I don't know who made the decision to do this again, but somebody did. I don't know if Councilwoman Simon knows whose decision it was. It wasn't mine. It wasn't hers. They weren't calling her back. The people in Cuyahoga County deserve better. So I thought we had a few words changed that needed to be resolved, but here we are. I can tell you, and I'll let Brendan and Nora speak to it. Yeah, 95% of what was here, we agreed to. Employment matters, we had an issue with because we do employment matters. And you can drive a bus through the term employment matters. What does that mean? We specifically had listed what we believe in good faith that they had done. And other employment matters are included in Section B under the HR department, which I believe is Charter Section 9?
9.05.
9.05. So it encompassed employment matters. So, and then Rick Manilov's correct, where it says are responsible to, we had the terms, which is a legal term, serves at the pleasure of. Responsible to is so vague. Serve at the pleasure of is precise legal termage, which means that he is their appointing authority. And again, and then what they did in D, they never ran by us. And it infringes upon what we do in our office. But again, this all could have been resolved. So I am sitting here today asking you not to go forward with this, to vote this proposed amendment down, and send the message that collaboration matters, doing what's right for the people of Cuyahoga County matters. And when you're trying to negotiate a resolution on behalf of those people, that you do so in good faith and you don't pull out the rug from your fellow office holder in Cuyahoga County. Quite frankly, it's embarrassing. Nora, do you want to speak to any of the other things in red?
Just briefly, Nora Poor, Chief of the Civil Division at the Prosecutor's Office. I think Prosecutor O'Malley correctly summarized just the points in red that were discussed by the law director. These are items that we did go back and forth on quite a bit, and the only reason we weren't able to agree upon it is just for the vagueness and the imprecise nature of the language that they were proposing, which could lead to disputes and arguments about what does it mean in the future. And that's what we are trying to avoid with this. We were trying to get to a point where everyone is clear on whose responsibility it is to handle which matters, and get to a place where everyone is in agreement as to the role of the law director and his department and the prosecutor and the prosecutor's office. As to the new language in Section D, that is language that we are seeing for the first time at this meeting. So that was something that was never seen until today. So just briefly looking at it, as I have while I was sitting in the audience, this does not seem to be just a restatement of what is in A. This seems to be a limitation on the prosecutor's elected duties. And I think going into these negotiations, we always wanted to make it clear that this proposal is supposed to be a grant of authority to the law director, not taking away authority from the prosecutor, who is granted that authority under the law, and he's an elected official who, from the first day of the charter, it always said that the prosecutors to be elected and that his duties remain as under general law. So this would be a restriction on that, which doesn't exist in general law. So I don't think including that would be appropriate.
Thank you very much. Any other comments?
I have a question
We're going to open it up for discussion. Yes?
before they sit down.
Yeah, Madam Chair.
But are you aware, Prosecutor O'Malley, that I have a substitute that reflects the proposed agreement that we had on Friday?
Yes, as I said earlier, Councilwoman Simon put dozens and dozens of hours trying to work this process to a successful conclusion. Like I said, when I couldn't get a hold of anybody, I don't think she could get a hold of anybody. And literally, but for a few words that were minor, I thought the issue was resolved until 12:45 today.
So my question is, when you ask the council not to support the proposed substitute, you are specifically referring to the executive substitute, not to the one that I had.
Yeah, I assume the one you have is the same one that Nora had sent?
Yeah,
Yes.
Yes.
We support that.
okay.
Yes.
Okay.
And that is 95% of this, maybe 96% of it. Again, it's just, yes, to answer your question, yes. This is the first time we've seen this, when Mike King handed it to us.
Through the chair, to the prosecutor or the lawyers at the podium, if I can, one of the main concerns of the law department, as I shared with you previously, is that some of the employment matters they're handling may not be covered by this language. And there's a fear in our department that somewhere, I've used the word snatch, that you're going to come in and take back some of the employment matters they're handling that are not specified necessarily in the reference to the charter chapters provisions.
Briefly, if I could speak to that, I believe that everything would be covered in their ability to advise the county's HR department, which I think would encompass those employment matters that they are involved in. The reason why we did not want to include it in subsection A is that those are to be primarily handled by the law department, whereas there are many instances where the prosecutor's office does handle employment issues for the county. So making it primary just didn't seem to fit quite right. But in many instances, there would be collaboration where we would both work on those things, and they're fully encompassed within Section B, which authorizes them to give legal advice to all the list of departments and agencies underneath the county executive. So they can advise them on employment matters through that provision B. It just wouldn't be primary. So I think that was the distinction that we were trying to make there.
Okay. MFLA matters, they can still advise, correct?
Correct.
As they've been doing.
Correct.
Is there anything that you see the law department handling under the umbrella of employment matters that you would want to assume if this charter, is there anything that your office would want to, I don't want to say take back because you already kind of have it, but to assume the role and responsibility that's currently being
I don't think
handled?
there's anything that we're not already doing that we would feel the need to get involved in.
Okay.
Yeah, quite frankly, if that desire was there, we have 10 years of demonstration that it's not.
Thank you. Those are my questions for now.
Other questions for the prosecutor's team? Councilman Sweeney?
Thank you. Do you intend to fire anybody? That's the whole thing.
No.
This whole thing is, that's
The
the
intent-
thing that is driving
Yeah.
my thought process
No.
and the worry of my coworkers.
Councilman Sweeney, up until 12:45, I thought everything was smooth sailing. So no, there was never an intent, there is no intent for anybody to lose their job. There was an intent to resolve an issue that I thought was in the best interest of everybody sitting here. Like I said, it was not my desire to put you in this position.
Thank you. And just another, you've been doing this 10 years, you said?
9 years, 9 months,
Going on 10.
yeah, no, 9 years, 8 months, 4 days.
Got it. And just, did you plan on changing the way you've been doing business?
No, there was no intent to change anything. Quite frankly, we sincerely hammered out 95% of an agreement, maybe 96% of an agreement that we thought everything was satisfactory until we got radio silence.
Yeah, I mean, that's all. I'm just trying to, what's going to change? If this passes or doesn't pass, it's been functioning as a law department like every other government that I've been in. They have their responsibilities, the prosecutor has theirs, and the Ohio Revised Code says something in regards to very
If we
specific.
were to allow this, if this went forward, it would change by taking things that we currently do and transferring those to the law department, as well as perhaps unconstitutionally infringing upon my powers under the general law through Section D.
Yeah, and I'm just talking about day-to-day functions. They're going to come in, they're going to go to their office. They're not
Correct.
going to go over to your place. You're not going to take this department and put them over there.
Correct.
You have a track record of 9 months or 9 years and 8 months of doing business, and it's been working. When I need something, I call the law department. If I need something from the prosecutor, I call the prosecutor. I get an answer, I get a great answer, and it's defendable, and I'm tickled pink when that happens.
Yeah.
So everybody's worried that this is going to be an Armageddon. I don't see it at all.
It's not. Again, I thought it was resolved or 99% resolved on Friday until I didn't get further communication.
Thank you, Mr. Chairman.
Council President Miller.
Mr. Chairman, I would like, if I could, to ask a few questions to the law director, after which I might ask a couple questions to the prosecutor as well, if I may.
Proceed.
And the first question is that the prosecutor presented a view of the negotiating process in which basically he and his office did everything right, and you folks did a number of things that that weren't right.
I'll take care of that.
Okay, I'll let you restate it. Yes.
To be clear, the law department and the prosecutor's office for weeks had constructive, productive dialogue that resulted in change after change after change after change that led to the creation of 96% of that document. So it was a very productive discussion. And like I said, Councilwoman Simon was invaluable. Councilman Sweeney participated, but I mean, everything was going fine, like I said, until Friday afternoon, where we never heard back from him. And if Councilwoman Simon, would you?
I did not hear back from people on Friday.
I know, but I'm saying we were having constructive dialogue.
Very. It's just a matter of words.
Okay, so I'm going to restate my question. I would like to hear the law department's discussion of what happened between Friday afternoon and now.
Okay, I can now speak to that. Honestly, Friday afternoon, I was in a national park in Utah, so that's where I was. I am aware, that said, that the latest draft of the proposed charter amendment was indeed sent by the Cuyahoga County Prosecutor's Office to the team, again on Friday afternoon. At that point, I would defer to Brendan Doyle and others to describe what happened from that point forward, because I got back from our family vacation on Sunday night. And then on Monday morning at 9:30, the law department met for 3 hours after that, and then the rest of the day, and then through the night actually as well. We talked about this, and only this, and so we have been working very hard for a very long time, as has been stated, I would say, both sides. And I agree with the county prosecutor that over the course of many weeks, productive conversations had been had. And from my humble perspective, and Brendan will speak more to your question. From my perspective, we did move the ball on a lot of issues, and ultimately we determined that we just need more. We need to protect on the employment matters, and I have Nora Hurley here, who's head of our Labor and Employment Division, ready to answer any questions and speak to the issue of essentially, as we see it, protecting a core function of the law department. And we had proposed that language as no later than July 22. So this is just language that we just haven't agreed to. We just haven't had time to flesh out the issues that the Civil Division Chief Norpour has pointed to. We just haven't had that time, but it's very important to the law department. This is core. It's a big part of what we do, and Nora Hurley can speak eloquently to that particular matter. And then I think the issue that we struggled with the most was the issue in subsection D, which honestly we believe to be simply restating what is in A. And if it is viewed as something other than that, if it's viewed as something that isn't consistent with what is said in subsection A, then there is the issue remains that the concern remains of the law department that a future prosecutor may take a look at subsection D for sentence. I have all these powers and duties under general law in section 4.01 of the charter, and I'm going to fill in the blank. I'm going to start taking over labor negotiations. Charter says I can do it under subsection D, and subsection D overrides subsection A, which gives that primary duty, that primary core duty to the law department. So that's the concern that's trying to be addressed by that added clause there. And again, to summarize and restate that piece of it, we do not see that as controversial. If A is acceptable, then that clause in D is likewise acceptable. But Brendan, if you could speak more to the Council President's question.
Yes, Brendan Doyle on behalf of the County Executive's Office. Council President Miller, in response to your question, we did receive the draft back from the prosecutor's office on Friday afternoon. I think it was somewhere around 1:30 or so. As the law director stated, he was traveling. The county executive is also traveling. And so we wanted to obviously have conversations with them as well as with folks internally regarding the latest draft. I agree with the county prosecutor. Our discussions, our conversations have all been in good faith. I think that the executive and the law director have made some concessions. The county prosecutor has also absolutely made some concessions, and I think we were all working together in good faith. I think Monday, the law director was looking at this draft that we received on Friday afternoon for the first time, and just trying to understand it. I think he also wanted to talk to the attorneys and staff in his department to understand where they stood and how they felt about it. I appreciated the questions that Councilwoman Simon and that Councilman Sweeney asked of the county prosecutor, because that is, I think, an overriding fear of many of the attorneys in the law department, that there is the possibility that the county prosecutor might try to take over some of the areas of law that the law department is primarily responsible for, and try to take some of those attorneys over into his office. Now, I also take the county prosecutor at his word when he says that is not his intent. And quite frankly, that has not been something that has happened since the 2017 MOU went into effect. In fact, the relationship between the prosecutor's office and the law department, I think, was working the best that it ever did. I think there was we talk about dialogue, we talk about collaboration. Those are very important things. I think last year, when the county prosecutor requested an opinion from the Attorney General regarding the powers and duties of a prosecutor and whether those could be delegated to a law director, and that was, the fact that that request had been made was not shared with the county executive, was not shared with the law director. While the law department and the prosecutor's office have been working so well together, that came as an enormous surprise to a lot of people. And so I think that's, where some of this distrust started. And so I think we have tried to work with the prosecutor's office, and we have negotiated in good faith. I think that, the points made regarding things like employment matters, Nora Poor, who is a good friend but also an outstanding attorney, she's right. They do work on employment matters. The issue is so does the law department. And so, I spoke to the county prosecutor last night around 6 o'clock to let him know the status of things. He had been trying to call me, and there were a lot of moving parts yesterday. There have been a lot of moving parts today. And I always try to get back to our county prosecutor as quickly as I can, but was not in a position until at 6 o'clock or so to be able to give him an update as to what was going on. So that's kind of what's occurred between Friday and today. Certainly, speaking for myself, both having worked for the county prosecutor, who I have enormous respect for, the attorneys that sit on either side of him are my friends. They are great attorneys. They are my former colleagues. They're my current colleagues. Mark Musson has also been a part of this effort from the prosecutor's office. He has been outstanding as well. I think we've all tried to work together. We will continue to work together. I think, again, I think there's just been a lot that's been a lot of moving parts. There's been no disrespect intended to the county prosecutor in him only learning late today regarding this proposed substitute. There was no ill intent there. And so obviously what's been proposed to you is being proposed in good faith and with sincerity, and wanted to just provide some of that information to all of you. And again, appreciate the efforts of both Councilwoman Simon as well as Councilman Sweeney. They have been integrally involved in these conversations in helping us to try to move things forward. So again, everybody here I think has been working in good faith.
Okay, Mr. Chairman, to the law director, I'd like to now focus on Section B and the responsible to language. And you referenced about the sheriff, the inspector general, and the Charter Review Commission in discussing that section. And as I read it, using the alternative language serves at the pleasure of, while that clearly wouldn't apply to the sheriff and the Charter Review Commission and the Inspector General, because they don't have officers that serve at the pleasure of, whereas I read this, the Inspector General and the Charter Review Commission are both in some way responsible to the council and or the executive, and that could be true of the sheriff depending on how future litigation is resolved. And so this language would seem to at least keep open the possibility that that the law department could continue to provide opinions to these three entities, which currently the law department has done in the past. Is that a fair reading of what this language is all about?
I believe that is a fair reading. That's an important issue. Again, the language itself was proposed back in July, taken, copy and pasted from the 2013 charter amendment that council had put forward. But as to your specific question, let's take the sheriff situation. Since you brought it up, the issue on the table that you point out is that the sheriff is appointed by the county executive, confirmed by council, but can only be removed under the current charter provision for cause by council. So the sheriff does not, quote unquote, serve at the pleasure of the county executive or council. It can only be removed for, not at the pleasure of council, for cause. And so that combined with no reference to Article 16 in the laundry list of articles cited there means that the sheriff is out, that there would be no specific authority in the charter for the law department to give legal advice to the sheriff and his department. Now, you referenced the lawsuit. Both the county prosecutor and I have recused ourselves for obvious reasons from that lawsuit. And so, I am not intimately familiar with where that lawsuit stands because I have recused myself from that whole issue. I will say, though, that if the issue is ultimately resolved by the trial court or whatever appeals might be had, that the sheriff's department, at least as it relates to administrative fiscal matters, does indeed report to the county executive, the chief administrative and executive officer. If that's the outcome of the case, then it would seem logical that the law department could then provide representation to give advice to the sheriff on those fiscal issues. When I first got here, more than 3 years ago, I would routinely give legal advice and write opinions on matters relating to fiscal concerns at the request of the sheriff and his staff. And so, one of the issues that you point out, Council President, is we want to try to get language in there, again, taken from prior version of a charter amendment that Council had proposed, that would at least open the door, if the court were to so determine, that at least as to certain matters, not matters of keeping the peace and law enforcement, but administrative fiscal matters, if those are ultimately overseen by, if the sheriff is responsible to, sheriff's department is responsible to the county executive, then this language would preserve our ability to advise, specifically authorize us to advise and give opinions on those fiscal matters. So that's, that's one of, I could go on, but you raised the sheriff in particular, and so I wanted to speak directly to that. So this would at least open the door for that, as opposed to closing the door by saying serving at the pleasure of. Of course, there could be charter amendments relating to the sheriff, and I can't speak to that. That could change everything.
So, Mr. Chairman, Director, regarding Section D, is it your opinion and that of your department that if the first sentence of Section D remained without any qualifying language as proposed in red, that the law department would be worse off than if no amendment were submitted at all?
We've tried, and I think in our draft, maybe it was don't know, July 22, I forget exactly, we had proposed deleting that first sentence completely. But it remains, and so the issue remains what to do, because the, as stated before, and I won't repeat myself, but leaving that sentence in there raises the concern of those in the law department that a future prosecutor could take that sentence and run with it and override that which is contained in A, which is the concession to have the law department provide primary legal representation on their core duties. And so, again, we struggled with this issue all the way along. And we tried different language. We tried to delete it, came back in, and now we're proposing what we think to be, hopefully, in our judgment, non-controversial, because it's restating what A says. It's that the law director shall provide primary representation on the matters set forth in 5.06A. Well, that's what 5.06A says. It's mirror language, and so there seems to be a disagreement on that. But that's the intent of it, is to deal with the fact that that's still in there, and that a future prosecutor, the current prosecutor, has stated his intent to not move forward with that. But who knows? But again, we're looking at this from the long view, as the prosecutor himself has said, looking at the long view here, and we're looking at future prosecutors taking a look at that and saying, well, I'm going to take over all labor negotiations. It says so. Indeed. So, yeah, anyway, that's the intent.
Final question to the prosecutor, if I may.
Thank you, Mr. Chairman. Before I answer, I just want to clarify, we changed the first section in Section D last week, and Rick was probably on vacation, but as a concession, we changed that section for them, where that first sentence for them. So I don't know that Rick knows that because he wasn't a part of it. So I excuse him for that, but it's not the same sentence that used to be in there.
So, Mr. Chairman,
Yes.
Mr. Prosecutor, just on Section B, again, regarding "are responsible to or serves at the pleasure of," do you agree that the language "serves at the pleasure of" would effectively remove express authorization for the law director to give written opinions and legal advice to the sheriff, the inspector general, and the Charter Review Commission? And if so, is that your intent, despite the fact that it doesn't represent current and past practice?
Well, that language was put in because, do you know what the term responsible means?
I think that I do.
What is it?
So, this is not an equal situation. I'm not prepared to get in a
And what I'm
legal
suggesting to you
disputation.
is there's a million definitions of responsible to. And what we were trying to do is narrow it so that it eliminates potential legal issues in the future. And when you put broad terms like employment matters into an agreement or a charter provision, which is why this thing took weeks, when you place a term like employment matters that encompasses everything, when in fact my department does these things, that's why we said, let's not have employment matters. We actually changed it to precisely include what they do that wasn't already included in one of the other provisions. So back to your issue with serves at the pleasure of. That is a precise legal term, as I indicated to you before. So, yeah, to me, it denotes that you are a appointing authority or you have some ability to remove. And so 8 years ago, you were here, half of yous were here. There was a charter amendment placed on for the sheriff, for instance. And that whole issue was, if those who were here may recall, it was, who does the sheriff, who's he responsible to? And I stood up here with the public defender and I said it should be elected because people deserve accountability. The citizens of Cuyahoga County deserve to weigh in who their elected sheriff is. I agree with the individuals back here who said it today. We're all elected. We trust the public to weigh in on our positions. The sheriff is probably the most important critical position in this county. And so we passed myself and the public defender came up and advocated for an elected sheriff. The council decided no, we would control that by putting on the Tuma amendment to the charter that said only council can remove them. Only council could remove the sheriff, whoever he or she was. So that is an example that, in my opinion, the sheriff serves at the pleasure of county council, right? He doesn't serve, and that's what the whole lawsuit is about. Now we have a new executive come in because he thinks that somehow that is not clear. So now we have a lawsuit pending. Who does the sheriff, who is he responsible to? I thought that was already resolved. But I can suggest to you, having the words "are responsible to" is inviting more litigation. Nora, you want to go on to responsible? Or Brendan?
Yeah, the only thing I'd say is this language "are responsible to," it is very vague to me because as a lawyer who represents the county and all of you, including the county executive in litigation, I'm responsible to you as well. So if you read this language, it leads to an absurd conclusion that the law director and the law department can give legal opinions to the prosecutor under this language. The language serves at the pleasure. We understand what that means. We understand what that means. It's concrete. We know what our role is. And the purpose of this charter amendment was to clearly define our roles. Language like this does not accomplish that goal. And that's why we just don't agree to it. Maybe more time, more discussion on this language would have helped, but as written, I don't know what that means. And if you don't know what that means, how can you vote for language like this?
Sir, if you could state your name for the record, please.
Oh, Brendan Healy, I'm sorry.
So, Mr. Chairman, to the prosecutor, does the serve at the pleasure language preclude the director of law from advising either the inspector general or the Charter Review Commission despite current practice because they don't have any officers that serve at the pleasure of?
That would indicate that we would be advising them, consistent with how we have handled in this charter amendment, the rest of those individuals who are not responsible. So what we tried to do is...
But, Mr. Prosecutor, it's not status quo. I thought the entire enterprise was to memorialize current practice, and the law department was the primary advisor to both prior charter review commissions and has provided opinions and advice to the inspector general at least from time to time. Your language
Just to be clear,
change
Mr.
current
Chairman,
practice.
Mr. President, just to be clear, we have also provided legal advice to the inspector general. And my understanding
The charter
is...
amendment would not preclude that. Section C says that you can,
Dale,
that your
I wish you
advice can
should-
be requested by anybody.
Dale, Mr. President, I appreciate the level of scrutiny with which you've provided this issue, but I can assure you, we have advised both the Charter Review Commission and the Inspector General, and I'm sure the Inspector General may be here, but we regularly provide legal representation and advice to the Inspector General. So again, given the fact that much of our, in some instances, not much, but in some instances, we were overlapping, and we will continue to overlap in some areas, that's okay. What we had crafted was a document that pretty well, and I think even the administration would say pretty well, attempted to codify exactly what our duties are. Can you do it 100% perfect? No, but I think we did it 99.9% perfect. And so we thought that was a big concession to the law department, and we thought that was in the best interest for the taxpayers of the Cuyahoga County. What isn't in the best interest is having a charter amendment that impacts my office not be reviewed by me before it was introduced. You know what I'm saying? So when the council president allows that to happen, that's not in the best interest of government. And quite frankly, that's not in the practice of how this council operates normally or should operate. But it's happened.
Mr. Prosecutor, this is the executive's amendment. I did not have any control over when and what substitute he submitted.
With all due respect, it was handed to a staff member of yours prior to the meeting and put on the agenda. At some point, I was owed the respect of a copy.
Just on that point,
We've got,
just on it, very specific to my council
very
president.
quickly.
Thank you. Mr. President, you have no role in this, but if he gave you a piece of legislation to walk on, you have to give approval to that, don't you? I'm just trying to clarify very accurate stuff.
This amendment was introduced by the executive. He has the opportunity to put forward a proposed substitute, and then it's up to us if any of us want to make a motion to make it the version before the committee.
Very good answer. I'll leave it alone for now.
We're going to move on with some more questions. Thank you, Mr. Prosecutor,
Thank
as
you.
well. Appreciate that. We're going to move to Gallagher, then Simon, then Kelly.
Ms. Prosecutor,
Mr.
Ms. Prosecutor,
Put me down for it.
you might as well not leave. It seems whatever the mix-up was, there was a mix-up. And I'm sure everybody's sad to have seen that happen.
I don't think it was a mix-up.
Ms. Simon's in the room. She's been working on this. Do you have concern or questions regarding her amendment?
No, if Councilwoman Simon is presenting what we worked hours on in good faith with the executive, and she was integral to resolving whatever there was minor issues.
I understand.
I thought, quite frankly, it had been resolved.
So you have no issues with her amendment?
No, I think
Lauder-
that amendment reflects precisely to the best that we can of what we do, and which is being done in the best interests of the taxpayers, our county, and the employees of both the law department and the prosecutor's office.
Mr. Law Director, do you have issue with Ms. Simon's amendment?
I
And
do.
if you do, why?
I do. For the reasons stated on the, in A, I feel it important as the leader of the law department to draw a line around our core functions and duties and say these are our core functions.
Okay,
And,
did you share your
so
objections with Ms. Simon?
Yeah, we did talk about employment matters. I believe Mr. Doyle talked. with
Employment
Ms.
matters.
Simon.
If I
Yes,
can, through
that's
the
right.
chair, to
We did.
Mr. Gallagher, to the law director. So this is a word called employment matters. And that is the sticking point. And I want clarification. I've got it repeatedly, that the law department can continue to do its employment matters. I know Attorney Hurley, if I could, she wanted to articulate why this would impinge or infringe on their ability to do what they're doing, if that word is not there. And as long as we're debating this, I think it's important through the chair that, in answer to Councilman Gallagher's question, to go through the list of 12 things, I think maybe 12 to 14, of what was, Nora, can you come up and say why you think my substitute would somehow infringe on your ability to continue to do what you're doing? Because that's the heart of this. The other is the sheriff and who he reports to. For me, that's a concession, and I'll talk about that later. But this is, I think, one of the fears of the office.
Through the chair. My name is Noor Hurley from the Cuyahoga County Law Department. The question that has been posed is the meaning of employment matters. What does that entail? And the prosecutor has stated that his office as well represents on employment matters, and so it does, particularly in litigation and so forth. The law department, however, engages in employment matters on a different spectrum. We represent on OCRC matters, Ohio Civil Rights Commission matters, charges, investigations, EEOC, Equal Employment Opportunity charges that the county has to answer to. We represent on ADA, Americans with Disability Act, determinations, accommodations, interpretations of the law, day-to-day questions from our Human Resources Department, how to interpret the law, how does that mix with the employee handbook, interrelations with the policies and procedures of the county. We deal with employee discrimination claims, complaints, retaliation complaints, hostile work environment complaints before they reach litigation, before a lawsuit is filed. We investigate, we assist HR to work through all the factual evidence. We'll engage and assist in interviewing witnesses in preparation for potential determinations and directions. We opine on ethics violations outside of the Inspector General before they get to that level, when we might, or HR or management brings those issues to us or brings them forward to HR. We have constant daily matrix matters that are entered into for our law department labor and employment group to answer. Questions that stem from payroll, how to interpret AWD hours with respect to this group of employees that work a second shift, how to accommodate all of our employees so that we can move forward. Benefits questions, legal questions on what happens when an employee hasn't timely filed for benefits and we learned later. The issues are countless, but overall, we both represent, you represent in litigation, we represent on the beginning end, before it gets to litigation.
Attorney Hurley, can I
Yes.
ask you, and I really appreciate you having a voice because you're there day to day for 16 years, but Section B, and I'm so sorry to my council colleagues, but this is important, it gives the Director of Law the power to give written opinions, legal advice to officers, departments, directors, boards, agencies, commissions, authorities under articles of the charter. Would you be precluded from doing any of those things which you just cited? Would this language here infringe on your ability to continue with those same duties or opinions, advice? You could still do all those things, right?
I believe so, but I cannot say that it won't draw into question the future.
Okay, well, this is where we are, and we've been here for, it's an existential threat. So this language here does allow you to do this.
Not entirely. I've heard the prosecutor here as well opine and state what he continues to do, and I find I'm confused because we're here to clarify something that we have agonized over since 2011, since 2010. This is round 3 of our challenges to try and delineate the duties and responsibilities, and the prosecutor has all of the duties of general law, and those still remain, but we are a chartered community that created a county executive, created you, a county council, and created a director of law that has a department, and that's what we're here to try and clarify. And The other concern that you raise, and are we precluded with this charter amendment as presented from moving forward on the way we've been representing thus far? If we look to Section D, that opening statement says, "This Section 5.06 shall not in any way limit the powers and duties of the prosecuting attorney as set forth in Section 4.01 of the Charter and General Law."
Right.
That sentence potentially undoes everything that is articulated under subsection A.
Attorney Hurley, we're in a position now without a charter that the prosecutor's office can do everything. So when we sit here and we're haggling over potential seizures of what you've been doing or existential threat, undermining the charter language, we have nothing right now but an AG opinion, correct? That says that our department is pretty much void of any of these duties until we have a charter. And in the question that the president posed to the law director, are we worse off? I would argue, of course, we're not worse off. Having something in writing that delineates what the law department can do, what the law department continues to do, is better than nothing. And we're letting the perfect get in the way of the good, and we're fearful of some existential threat that this prosecutor is going to come in and seize these things and come in and take your jobs. That's not, I believe, what's going to happen. And to sit here and say that we are not better off by having something in writing, in a charter that gives your law department powers and duties, at least they're concurrent, when you have nothing right now. Nothing. So I frankly, the pushback and piecemealing and all of these things, I'm going to argue, make no sense because you're not going to give everything. You're not going to have the sheriff reporting to the law director. You're not. And we're not going to have our law department counseling the charter review. These are concessions that, fine. But when we look at the big picture about having some stability in the law department, here we go. That's my position. And you have a fear that somehow what you're doing is going to be taken away. And I'm glad you were able to recite those things you do. It's important. And you even agreed that this language is not going to impinge or infringe your ability to do it.
I didn't say that, but.
Well, I think you did answer. You didn't
say that. That's not what she said.
Oh, wow.
Mr. President, I know you had a quick question.
Yes.
Thank you.
I
will respectfully step away.
I have a clarifying question to Ms. Hurley.
Yes.
The question is whether legal representation as written in Section A encompasses more than giving written opinions and legal advice as written in Section B, or is it essentially the same?
So sorry. So I don't know if I'm looking at exactly what you are looking at.
In Section A,
Yes.
it talks about giving legal representation. In Section B, it talks about giving written opinions and other legal advice. Does giving legal representation encompass more than giving written opinions and legal advice, or is it essentially the same?
In my opinion, I believe it's more than just giving legal opinions, but again, we can go back and forth. I want to make sure I answer your question. Can you restate it? Because
The question is whether giving legal representation, as described in Section A, is broader and more encompassing than giving written opinions and legal advice as described in Section B. If that's the case, then the fact that the HR section is cited in Section B might not fully solve the problem.
I want to say yes, that I'm agreeing with your statement, that just referencing 905 of the charter with respect to those particular matters enunciated, we currently do more than what is simply set forth in 9.05. But again,
Okay.
Councilman Gallagher.
Real quick, and Mr. Chairman, your call, but I would like to move Ms. Simons forward. Why doesn't Summit County have this problem? We were supposed to be the mirror of Summit County until very strange things happened. So
I don't know.
does anybody, I tried looking it up. I can't find anything out of Summit County that's problematic like this with their law department and their prosecutor. Does anybody in the room understand why this is happening here?
I cannot.
I'm sorry I said that, but I understand. Again, it's a simple question. Why is it only in Cuyahoga County? And we are supposed to be a mirror of Summit County, and we know we're not. And nobody seems to know how that changed. So why doesn't Summit County have these problems, have this problem? Anybody?
It's a good question.
And again, Mr. Chairman, I would move forward with Ms. Simons if everybody's in agreement.
Mr. Chairman, we do have, did you make this last night?
No, I did not.
We have a list. Somehow today I received this list of things that the labor stuff at the law department does, and we went through that list and we highlighted exactly where in the charter that it is already permissible, so that may help people understand that employment law is already covered in multiple areas in the charter.
Councilman Kelly.
Well, what happened with his motion?
I'm seconding it.
Okay.
We want to continue discussion? Let's continue discussion.
Just on a point of first and seconds, was there ever a first to, and a second for the administration's legislation to be received by us and discussion? So I just want to be very proper in regards to the way we do business, stay within our, so there's never been a motion, so
No.
I don't want to make the motion for the administration's legislation, the amendment. I don't believe there was a motion to begin the discussion.
That is correct. I would like to keep it open for further discussion. Yeah, we're not even at that point yet, so.
No, I don't think I want to talk about it anymore, the administration's, because there's not been a motion.
Correct.
We shouldn't be talking about it unless there's a motion to accept the amendment for discussion.
I'm going to let Councilman Kelly make his remarks, and then we can continue with this piece, followed by
What?
Councilman Kelly.
Thank you, Mr. Chairman. So what I've been hearing in the last hour and 50 minutes or so is that, I want to be respectful while I do this, but there has not been enough time to get everything in agreement. Vacations get in the way. Parts start moving places. I don't know if we're even ready to try to move this forward. We have a Charter Review Commission next year. And if we can't come to an agreement amongst parties, I don't understand why we're going to even try to do this. However, if push comes to shove, I would support Ms. Simons' amendment. Thank you.
Well, on that point, Mr. Chair, to Councilman Kelly's point, going back to Councilwoman's point, if we don't put anything forth, is it according to the AG, we don't have anything in substitute in writing right now? So I think if her statement is true, then we have to make some decision to move. So just to the councilwoman.
Thank you. Absolutely. All we have right now is an Attorney General opinion from the state of Ohio saying that that our law department is void of any powers and duties, and without a charter amendment, that stands. And that's how and that's going to create more existential fear and I believe conflict potentially with the prosecutor's office. So all we have is an AG opinion saying that our law department cannot do any of these things.
Councilwoman Turner.
Thank you, through the chair. I'm thinking as a teacher, and if I was asking my students to complete an assignment, what would they need to do that successfully? And based on what I've been hearing, I'm not an attorney. I'm an educator. I can learn. I'm listening, but I feel like there are gaping holes in my understanding of what both sides are suggesting. And I feel very uncomfortable moving in either direction at this point, and was curious, is there a third party or a neutral entity that could give us some type of education before we make this decision? Does this have to happen right now? I believe that something should be done. I'm just not, I mean, your son, Councilwoman Simon's a great lawyer. She's arguing her point. The prosecutors, they're making their points. Mr. Maniloff, all great presentations. So I just feel, is there a neutral party that could consult with us?
I think it's a good question. My concern at this point is that it seems like we're being left exposed. And so we have three options. Either we have two amendments that we could consider, or we let it sit and we move forward and Charter Review will review this next year. So ultimately, I think what we should do first is, does anybody want to make a motion for the administration's substitution? My guess is no.
Mr. Chairman,
Council President.
I will make that motion.
And that's for the administration. So just a point to the chair. So future, I'm in the mind to do something today. So in the future, if we did move it to Charter Review, how do we know who's going to be on that Charter Review? Do we know if they're going to have legal expertise? I mean, it's going to be kicking the thing down the can. We don't know who's going to be on the Charter Review. So will they have legal background? Some of us don't, but you know, we've heard from 3 different lawyers, 4, maybe 5 today. And, you know, it's like council. You can have 11 different votes on something. So I think it's up to us to make two kind of decisions is what I'm hearing. Not to leave us kind of in the open for litigation or something like that. Possibly move it to the voters to make a determination. And the other part is that we have 3 outstanding, I don't know how big or little that they are, from both sides that they don't agree on. So the majority is agreed upon. I think that goes to Councilwoman Simon's point. Is there something that we can do today, because we've been asked from the prosecutor and the law department, would they still work together on this? Could we make a determination today and move it forward, if that's what the majority wants to do, and still have consensus amongst them, that the prosecutor and the lawyer still continue on these 3 points? Even though we're going on recess, I know everybody's trying to blame it on us going on recess, the council president has the powers and duties to set a special meeting. If they were to continue, we do the 95% vote, which to move it out of committee of the whole and let them continue to work. You can ask both of them their question if they were willing to do that before. It's a compromise to everybody.
Thank you. Mr. Chair, I just want to say one thing. I was a neutral when, I just want to be clear, I'm not arguing a position other than I came in at the end to mediate this. That's my position. I didn't come in with an agenda. The only agenda I have is I think we cannot be exposed. We need a charter amendment. I came in to mediate both sides of this. I was in both offices for hours on end. So this is not my outcome. This is a mediated outcome. And I think that's really important to understand, that this is, both sides, this is what we came up with, this is the product. And it's not perfect, I said that. This isn't mine. This is everybody's position consolidated in this amendment. It doesn't satisfy the law department entirely. I don't think the prosecutor's office is overjoyed by giving up primary duties to the law department. They don't have to do that right now because of the AG's opinion. They came in good faith. I was able to come up with something, and this is it. This isn't mine. This is a mediated product.
Mr. Chairman, I'm still waiting for a second so we can have discussion about this.
Okay.
We've had a motion. If we don't get a second, we shouldn't be talking about it.
Is there a second
For the
First
for the
Amendment
good
from
of
the
the whole,
administration?
yes, I give a second.
Okay,
Thank you for the procedural.
thank you. Do we need a roll call for this?
So I'd
Or
like
no?
to, I'd like to speak to the motion.
Council President.
So, Mr. Chairman and to my colleagues,
Mr. Chairman, put me down,
this,
please.
this amendment before us now, the one that the executive submitted, is the closest thing to accomplishing what both parties described from the outset was the primary goal, which is simply to memorialize the status quo and to let everybody keep doing what they've been doing. If we do the other version, it reduces the law department. It eliminates things that the law department is currently doing. It takes away the law department's ability to represent the Inspector General and the Charter Review Commission. And as a council member that worked closely with the Charter Review Commission, that's very important to me. It probably removes the opportunity for representation for the law department to work with the sheriff's office. It raises questions about things that the law department currently does with employment law. And most important, the first line of Section D, without qualifying language, calls into question all of the things that were granted to the law department in Section A, which is said to be the primary concession and why this might be worth doing for the law department. I don't agree that Ms. Simon's version is preferring the good over the perfect. I do think it would be worse than nothing. It would enshrine language into the charter that would give the prosecutor's office more than it currently has and open up the possibility in the future for them to take more. It's not a fair and even-handed solution. The proposed substitute that's under consideration now, it is a fair and even-handed solution. It's the closest thing to the status quo. I think even this probably nibbles around the edges at some things the law department currently does. It certainly doesn't add anything to the law department's responsibility. It just hopefully gives them most or all of what they currently do, and it certainly doesn't curb anything that the prosecutor currently does. In Section C, it allows them to give opinions to anybody that requests it. In Section D, it confirms their basic general law authorization with the one qualification that that Section A is protected. It's a fair and reasonable solution, and I ask for your yes vote to make this the version before the council.
Excuse me, Mr. Chairman.
Yes, sir.
So we have a first and a second on Ms. Simon's amendment.
This is on there.
We did.
I
I don't think
understand
that
that,
was
but we had a-
withdrawn.
Didn't we have that prior to this one?
Yeah, that was, I think,
So
we've got to,
which one are we voting on?
we've got to withdraw the first and second on the substitute I introduced, so I'm going to withdraw my second. And it was Gallagher who moved at that point.
So now we're discussing the administration.
You are withdrawing your second?
But, well,
your own
first, we're going
amendment?
to do the executives and then come back and see if we want to substitute.
Correct.
Procedurally, asked Mike King, is that correct? Yes? Okay.
Councilman Simon. Sweeney, not Simon.
Simon and I kind of have a similar thought process once every a while. Mr. Chairman, thank you. I'm going to go with mind-numbing, what we're going through right now. And I have a bunch of little notes that I'm going to try to take some time. And to my council president, that was your opinion in my eyes. And you used the word probably. I don't like to live in probably when we're talking about charter amendments. Just to my law director, you mentioned in A, that you'll try to work through in your statements. We're about to pass something or not. And when you use the words try to work through, that means there's some more active discussions that need to be done. Can you respond to that?
I don't recall the context in which I said that. I believe that the...
It was with employment matters including.
Right, yeah, the issue there is that, and Councilwoman Simon has been a part of these discussions.
I know
and
that.
Thank you
You can talk
to
to
her.
me. Just let's go straight up.
That's fine. We had proposed employment matters, and then what we got back on Friday afternoon was PRC matters, and we want to go back to what we had suggested on July 22, employment matters, because it's a significant part, as Ms. Hurley has described, of what the law department currently does as part of our core functions, as part of the division. I'm sorry.
I'm just referring to the words try to work through when you're testifying to us.
Yep.
Now you're being much more clear, so I thank you for that. And then you mentioned with C, you made concessions.
Right.
I think that's no concession. I think that's agreed upon. So it's really not a concession.
And
Does that make any sense?
the concession was on the part. The issue initially was essentially it could be called forum shopping. It could be called a number of things, but it's a policy issue that was thoughtfully and seriously debated. Ultimately, you guys are the policy makers again, and so whether to permit any individual to seek multiple opinions is a policy matter for the policy makers, and so the concession there was to say, instead of you do this and we'll do that, it's like, well, okay, now everybody can do it.
I'm good with your answer.
Yeah, okay, that's
Mr.
fine.
Prosecutor, can you tell me if you made a, can you come back up? With C, was that a concession for you, or was that just normal business? Concession
by
means
the-
that they gave something up.
Yeah.
Mr. Chairman, to the councilman, this entire event has been a concession.
I'm just talking about very specific. He says you conceded, you gave them something in C. Did you give up something?
Well,
Did you concede? They conceded to you saying, we'll give you this. It was a concession on their part.
there was, without over-exaggerating, there was probably 30 concessions going back and forth. I mean, it was a constant concession back and forth, and the
No,
law
but this one
department-
specifically. I'm just trying to understand it.
Which,
C, just the C, nothing in section 506 prohibits the county executive, county council, or any officer, department, or director's boards.
I wouldn't call it a concession. I think almost C was a joint drafting.
That's
We had-
exactly what I'm trying to talk about.
Yeah,
It's
I mean,
not a
it-
concession.
it was
It is
like-
a joint understanding of each other's thought
Correct.
process.
At one point, employees was listed there. We went back and forth. I think the law department asked for employees,
Yeah,
then we
it was-
decided.
it was
jointly
mutually
to take
agreed
it up.
upon. There was no concession.
Correct.
Thank you.
Quite frankly, the whole document was an evolution. There was probably
But
30 versions.
Mike, or Mr. Prosecutor, I just really want to get to the word concession, and you answered it.
Okay.
It's not concession, it's mutual. And through the chair to my law director, you kept stating it's repetitive and restating in D. If it's repetitive and restating, why do we need it?
Initially, we didn't think we needed the first sentence at all, but yet, and we suggested taking it out all along the way, as recently as, I think, July 22nd. It remains in there, and again, the concern is a future prosecutor could take that and run with it. And say,
I'm just talking about very specific, the word repetitive and restating. If it's somewhere else in here, why do we need it? Because it's repetitive and restating. We don't need it again. Is that, am I just missing it?
In our judgment, it does restate A, but it restates A importantly. It restates A in the context of that sentence, the first sentence in D, and it qualifies it and it clarifies it to say.
It's really not repetitive or restating. It's clarifying to make it more whatever. It's not, when I hear repetitive and restating, I hear identical. And you use those words a lot, so they're not identical. Would that be accurate through the chair?
No. The language is important to have in there from the law department.
Asking the question, restating and repetitive.
I'm sorry. Yeah.
Oh, this is mine, not me.
Yeah. The point there is that the first sentence restates what's in 4.01, and so if we're going to do that, we're going to restate what's in A. But the issue again is context, because I'll get into the words now, if I may.
Please.
Thank you. This section 5.06, the entire 5.06, all of it, including A. Including the provisions that say that the law department is the primary legal representative on the following matters. So this section, including A, shall not in any way limit the powers and duties of the prosecuting attorney as set forth in 4.01 of the Charter and general law. This county prosecutor has stated his intention that that we're just going to go with business as usual, and that's awesome, because I really enjoy working with the prosecutor's office and have in my 3+ years here. That's not to say, though, again, we're looking at the long game, that a future prosecutor might take a look at that and say, okay, I have the authority then to under general law, to do labor negotiations. And so we want to make it clear here in the context of this sentence that despite that future prosecutor's desire to do something like that, that the law director is going to still provide primary representation on those core matters identified in A. So it's because that sentence is in there, it raises not an orange flag, it raises a red flag, and we want to clarify that through a clause that says, if a future prosecutor wants to, I keep coming back to an example of taking over labor negotiations. There may be concurrent jurisdiction on a lot of things, but as to who's primary on what, the law department's going to be primary on labor negotiations. And so as a result, we don't see that clause as controversial. However, we think it is necessary. Does that answer your question?
No, my question was very simple. If it's repetitive and restating, like you've said, why do we need it? And you should explain why we need it.
I've tried.
But it's not repetitive or restating. My definition of restating and repetitive is identical. Just restating. Apparently, it's not. So when I'm listening to you, you're my law director. And when I hear your words, I take that as gospel. So I'm just trying to clarify the words that are here. Okay, if Mr. Doyle would come up, I have two that he mentioned. And they're very brief but specific. You mentioned, through the chair, hello, Esquire.
Good afternoon.
You mentioned the AG's letter that went out, and you were kind of strong, saying that's where the distrust started. And I'm just trying to get my thought process is we have an elected prosecutor that's doing his job. He sees a piece of paper that he has a question about, and he sends it to somebody to answer the question, and he gets the answer back, and that started it. So if we're going to try to use the argument of he didn't tell us, so we don't have to tell him, I believe that doesn't make any sense to me. Can you talk about that?
Yeah, so through the chair to the councilman, respectfully, that I was not saying that, that because he did that, we did this. That's not what
Not the
I'm saying.
people in your office have, and your coworkers, just for the record.
And so, no, what I'm saying, and I think I would also say that, the prosecutor absolutely has the right to ask that question of the Attorney General. It's a question that the prosecutor has asked himself for years. And so, him asking that question there's nothing wrong with him asking that question. It's understandable that he would maybe want to get clarification. I think the issue was that.
You would appreciate a heads up, and I can live with that.
Yeah.
Thank you. And then the 6 o'clock return phone call. Thank you for doing it. And I enjoyed, through the chair, being part of this. I'm not a lawyer, but I think I was trying to add value in the comment, the last 11 words. Councilwoman Simon is more technical, but I'm just trying to be productive. But the 6 o'clock phone call, when you chatted with him and you returned the call, did you mention anything about the possible an amendment being drafted?
No, not at that time. I think we were still trying to, and again, as Councilman Kelly referenced, there were a lot of parts that were moving.
Oh, absolutely.
And so I was, I think we were literally acting in real time. And so I think that it was not something that had been, I don't think we were even there yet. And I think we were still trying to work through, we were here at the office until
perfect.
about 9 o'clock last night, trying to, work our way through
That's all
this.
I need. For my brain.
Yeah.
And I believe you more than almost anybody in this place. For you to tell me that it wasn't baked in, I fully believe that, and I'm 100% confident. And I was just trying to ask the question for the sequence. It's both the process that went through, but also the content. I'm balancing both, and I'm going to thank you for coming up again, and I won't make you do it.
I appreciate
For a
that. Thanks,
while.
Councilman.
And the last thing I'll bring up through the chair is governing by last-minute amendments to charter amendments. I'm going to go, it's nuts, right? I just got this one. It seems like our council president had time for digestion a little bit more than myself, at least, because he's very specific on it. And then I get the esteemed, wonderful colleague, Councilwoman Simon's amendment. There's 1 page of red. There's 2 pages of red. There's that 3rd page of red. I haven't even read it yet. I want to get knee deep into this thing. So to govern this way is baffling. And I don't like doing it. For me, it's reckless. So thank you, everybody, for listening to my questions. I thank everybody for answering my questions, and I appreciate the opportunity to share my thoughts. Thank you, Mr. Chairman.
Thank you, Councilman. Council
Chair.
President. Let's start with Mr. Jones and Council President Miller.
All right. So I was having to listen to all of these, to everybody's perspective, and I'm still trying to understand everything. It was my expectation and hope, my hope, that both sides would get together and come to a resolution, and we wouldn't have to try to figure out lawyer work to a certain degree. It's our work, but then 3 points of contention based on the administration's legislation, the 3 points of contention, the employment matters are responsible to, and the law director, again, carving out his portion in Section D. I'm not going to say I fully 100% know what the correct answer is. And again, I say I wish they had been able to work it out and not. But we're under a timeline. If we're going to do this, September 4th is the deadline, and we don't have another committee meeting before that. If that's the September 4th, there's a Tuesday before September 4th. I don't know if there's an opportunity to create space so that we can do our typical small groups and within the sunshine laws or whatever, and hear and give ourselves time that we did not get, because we're making a charter amendment. You know, it cements everything in, and to do it on the fly is not typical. It's not how we would normally do business. I don't know if there's a way of building a little more time in, since it's all been thrown in our lap, since there was not a decision made amongst the 2 parties. Perhaps that's a pathway. I'll let the law department and everyone else let us know our time frame, if that's a possibility. If not, I'll be ready to vote, and I'll make the best decision I can based on what I've heard. But if there's time to give us time to discuss and bring these 2 parties further along. We have Councilwoman Simon, who certainly is our resident lawyer on council, and she has made a decision. Okay, I don't know how both parties, obviously we've heard what they think about both parties' perspective on it, but she's come to a conclusion in her mind. But again, time would be my first thought, if it's even possible, to build in a little time for such a weighty decision. Thank you.
Is there any further discussion among my colleagues? Madam Vice President.
I just want to rehash. I think my proposal is fair and equitable to move this out of the committee of the whole. It's going to move. It's either going to go up or down, whichever way, when it goes to council. And still have not heard from either side if they would be willing, while we move this out, to still work on these 3 issues, because I think that's the whole contention. So would love to hear from the prosecutor and the law department if they would be willing, because I'm apt to move it out today.
I share Madam Vice President's sentiments.
When you're done.
Yeah. I'm going to let Councilman Kelly, and then I can speak after that.
Okay, so you're going to move what out? You're going to move, okay, what about the other one? Move them both out?
My suggestion is we start with the administrations and see where things fall. And then I think we see where Councilwoman Simon's amendment falls, and then we move forward from there.
Let me, if I may, give that back to you.
Mr. Chairman.
Mr. President.
procedurally, I would add just a little bit that, that we're soon going to vote on the administration amendment. And regardless of whether that amendment passes or not, Ms. Simon's amendment could still be moved as an amendment. And we would end up with one or the other. There wouldn't be a scenario in which we move both versions out of committee. It would be one or the other.
Okay.
Mr. Chair, I just want to point out that this substitute that I've presented is a mediated result of ours. It's not perfect, but part of what goes into this is to make sure that not one side is totally annihilated and that they'll be able to work together. And I think that's what this does. And if we just take one position to the extreme, it might cause a lot of chaos later. That's all I'm going to say.
Mr. Chairman.
And I agree with Council President that ideally all of these things should be in here, including charter review, but as it's not the ideal world that we're in right now.
Mr.
Council President.
Two things. One, I have to respond that this isn't a mediated solution that you came up with. When you got involved, you listened to the arguments and came to agree with the prosecutor's version on all the points in dispute and brought forward a version that does that. So it's one side of the argument. It's not a mediated solution.
You weren't in the
second-
room, Council President. I need to stop you right there. You've never been in the room. You've never spoken to me. You've been absent. You've been out of town traveling. So for you to come in here and tell me what I've done when you've not uttered one word or made one communication to me, I'm objecting to that. It's not true what you're saying. Where are you getting your information? You could tell me after. But unless you're in the room and understood what happened, you have no legitimacy to make these statements. And I'm not going to let you stand there and make statements that you are not privy to what occurred and what discussions took place to make sure that the law department's position was protected. So that is not correct. And I'm going to object again if you continue to make statements for which you have no personal knowledge.
So your statement is false. We had discussions, and I'm not going to say more than that. I'm just going to add one more thing that I checked with Trevor McAleer, and unlike the HHS, where the Board of Elections deadline is tomorrow, we have until September 4th to submit a charter amendment. You know, I don't know if it's feasible or if people want to try to do something using more time, but just I think I have the responsibility to let people know that at least that option is theoretically open.
Thank you, Council President.
Mr. Chairman.
Councilman Sweeney.
Thank you, Mr. Chairman. I just want to give a shout out to Councilman Jones for being accurate on the September 4th and being validated by my Council President. What are we doing, Mr. Chairman, if we vote for it's to move it out? I thought today was the day that we're going to move it out move it out of here, but not on the council tonight at 5. It won't be on the agenda.
So, Mr. President, if the motion on the floor passes, it simply would make it the version of the amendment that's in front of the council. It would require another motion after that to move it out of this committee to the full council for a vote tonight.
And the vote tonight would be to place it on the ballot. There'd be no more discussion.
Correct.
So all through, go ahead.
And presumably that final vote to move it out of committee, that vote wouldn't take place until anyone who's want to propose any amendments has had them presented and considered. And when we come up with the final version that we have in committee, then the vote, then it would be up to us if we want to move it out of committee.
Thank you. And through the chair, and it's just on the politics side of it, just to let it out of committee gives it more hope to be able to get to the final four or to the final council vote. As we talked about, the reason why you chose not to let it out of the committee for the charter review for the sheriff is because you don't know what's going to happen at the council meeting at the end. So for all of us, if we pass it out of here, if we don't pass it out, it stops. If we do pass it out, it's still hope alive. And just in my brain, if you don't want it, you don't let it out, because all kinds of funny things could happen in further discussions, as my council president taught me last week. So I look forward to the vote when you call it.
Okay. Councilman Hauser.
I will say this through the chair, because I haven't spoke. I'm going to be blunt. This should have been taken care of before now. I agree with, I don't know why we get things 10 minutes before council starts, and then we have to make a decision on the spot. We are not lawyers. Our only lawyer is Councilwoman Sunny Simon, who has a proposal. I am in support of the Councilwoman's proposal. I don't know what, I'm not sure why this, I've had conversation 2 weeks ago. I was assured this would be taken care of. And so as a county, as a whole, we have to do a better job. I am going to support the time that Councilwoman Simon voluntarily came up with this proposal. I'm in agreement. I don't want us to let perfection be the enemy of good. And I don't think, you know, we keep kicking the can down the road on everything in Cuyahoga County. And so for us not to have anything in writing, I think is going to be a disadvantage of us. I'm in support of Councilwoman Simon's proposal. Thank you.
Mr. Chairman.
Yes, Councilman.
Yeah, thank you. And I haven't said much on this matter either, but, you know, it is a little frustrating to walk in here quarter till and find out that there's a new proposal when you think there's progress has been made. And I spoke to Ms. Simon. I know she was working hard on this. I appreciate her efforts. And even that, some of it, as hard as she's worked on this, I'm really supportive of what she says, but I'm a little uncomfortable voting on it because I just use the same reasoning why I'm not ready to vote on this. But I know we do have that deadline of September 4th. It might mean more work for us. But I think that if we're 95%, if we're that close, we can't get that close. We can't figure this out by September 4th. And that, I don't know how that's going to work exactly, but I think I'm in favor of a little more discussion on this. And with that being said, I do appreciate the effort put into this, especially by one of my colleagues, Ms. Simon. Thank you.
Other discussion? Other questions?
Just, Mr. Chair, thank you, everybody. Like, this isn't, I really want something in a charter, you know. I think it's for the best for the law department, and that's why I worked for this. It's been 16 years without any protection, and then we got the IG opinion, which undermines every single thing that's happening in the department. So hopefully you'll get more time. We maybe can get some clarification on the employment language. That would be great. You know, other than that, good luck. I mean.
All right, so it sounds like we have two options. Move both of these forward to a vote to move them out, or we discuss more discussion.
Just procedurally?
Procedurally.
There was a motion and a second on the Simon resolution, but the motion was withdrawn. And
correct.
So we have to have another motion to make it active again? Because you're talking about voting on both of them.
Well, right.
So I'll make the motion for,
Mr. Chairman.
I'm just trying to understand.
We have to get through admins first.
This one first?
Yes.
Okay.
We can't send two out of here. It's one version or the other.
I do too.
And both can be fully considered. No one's going to get left out.
So I think ultimately what makes the most sense is to consider both. We have them both. We've been talking about this for months and months. I think one of the most important things is however we come out of here, we need to have some assurances from both the law department and the prosecutor's office that we can continue the conversation if September 4th is the deadline and if we decide to have another piece. But I do think that we've had ample opportunity to discuss, ample opportunity for us to share and collaborate. I also share Councilman Hauser's sentiments. At a certain point, I have a phrase in my head, but it's not appropriate for council, but we need to quit kicking it down the street, and it's time for us to lead and actually make a decision. So what we have before us now is the admin's amendment. We've already had a proposal in a second, so that would open it up to a roll call. Is that correct?
Correct.
Okay.
So this is on the executives?
Yes.
Okay.
So let's go ahead and open it up to a roll call.
And Mr. Chair, if I might ask one question.
Yes.
What this does is allows us to move both pieces forward or?
No.
Just the administrations.
This, what this would do, it doesn't move anything out of committee.
Okay.
It would just make the administration version the version of the amendment that's before the before the committee. And that doesn't close off further amendment. If it passes, Ms. Simon, if she desires, can offer hers as a further amendment. If it doesn't pass, Ms. Simon can do the same. It just
Maintains the status quo.
It just, right now, we have the early as introduced version, which nobody agrees is going to be submitted. So this would just make this the version that we're dealing with.
Just for colleague Jones, I'm not supporting the amendment of the executive, the substitute that's before us.
But your amendment is not excluded now. It's still a viable option.
Well, ultimately, you're going to have to choose which version you're going to vote out of committee.
Or not. But we're getting time. Got you. I'm good.
So we're going to start with the administration's proposed substitute. And Madam Clerk, if you'll call the roll on this particular piece.
Calling the roll for Resolution 2026-0182 on behalf of the administration, Mr. Sweeney.
No.
Mr. Castleberry.
No.
Mr. Gallagher. Mr. Schlepper.
No.
Ms. Conwell.
Yes, because I didn't get my things clarified, if they would be willing to still work to move this forward. So it's yes at the moment.
Mr. Jones.
I'll say yes.
Ms. Turner.
Yes.
Mr. Hauser.
No.
Ms. Simon.
No.
Mr. Kelly.
No.
Council President Miller.
Yes.
The motion fails with 7 voting in, casting dissenting votes and 4 voting in the affirmative.
Okay. Very good. Okay, so then I think this moves us forward to Councilwoman Simon's substitution, which we can
Okay.
certainly open up for discussion and then vote
Sure.
the same way that we have.
Okay, so I'll make a motion to move my substitute
And I'll second.
positively. Okay.
Second.
We have a first and a second. Is there any discussion among my colleagues? Okay, Madam Clerk, if you will call the roll.
Mr. Sweeney.
No.
Mr. Castleberry.
No.
Mr. Gallagher. Mr. Schlepper.
Yes.
Ms. Conwell.
No.
Mr. Jones?
Yes.
Ms. Turner?
Yes.
Mr. Hauser?
Yes.
Ms. Simon?
Yes.
Mr. Kelly?
Yes.
Council President Miller?
No.
The motion carries with 7 voting in the affirmative and 4 casting dissenting votes.
Thank you, Madam Clerk. So then at this point, the piece that would be moving forward would be Councilwoman Simons.
So, Mr. Chairman,
Council President.
the Simons version has been accepted as the version of the amendment before the committee. But no action has been taken yet to move it out of committee. If the council desires to do that, it would require a motion.
I'd like to make the motion to move it forward.
Second.
Okay. All right.
I have a
Mr. Chair.
question, and this was Councilwoman Conwell's question, if there's any time to make any further progress on this. And we have, what, between 3:30 and 5 to do that, for the parties to come together, to see if there's a way to talk about employment. And, okay.
Thank you.
You're
And
welcome.
I think that's actually a really good idea. So what would we like this discussion to look like?
Well, they can have the discussion.
Right.
I would like to move this out of committee in its version, and if there's any, if the parties can come up with anything that they're satisfied with, we could always amend it, I think, if it came back after 5.
Came back. Okay, very good. So then,
So, Mr. Chairman.
yes.
So, to Ms. Simon, are you talking about voting it out of committee now, but then if there's something that comes up, we would consider it at the council meeting?
Yes.
Okay. And I'd like to ask a question of the law director, if I may.
President.
To the law director, in its current form, this amendment contains the first sentence in Section D without any qualifying language. Based on that fact and other facts that we've discussed, is it your recommendation that this version would cause more risk to the law department than doing nothing, and therefore you advise us to vote against it, or do you advise us to vote in favor of it?
That's been asked and answered. He thought it was more risk, but go ahead.
To the chair, I asked the question, and I would like the law director's response.
The law department believes that the clarifying clause in Section D is necessary. And without it, I can't say that the law department would support this.
Thank you.
Other questions for my colleagues' discussion? Councilman Kelly.
Thank you, Mr. Chairman. I'd like to ask the prosecutor. On Section D, do you agree with what we were just told?
Thank you, Mr. Chairman, to the councilman. As I indicated before, there was first a concern with the first section, the first sentence in D, and the law department expressed concern. So I think on Wednesday night or Tuesday or Wednesday, I don't know if Councilman Simon remembers, but Tuesday or Wednesday, we changed it for him. Thursday. The days were all blending in. But Thursday, I changed the sentence for him, and I thought everything was good. And then we got radio silence. So literally, we got this language at 1:45 today. Hadn't seen it before then, haven't talked to my staff regarding it. other than of the fact that they indicate that they believes it infringes upon our authority under the general law. So we hadn't seen it.
But, Mr. Prosecutor,
And so, yes.
this is Ms. Simons' amendment.
Okay,
That's
Ms.
the
Simons'
one
amendment?
that's the one we're moving forward.
Okay.
What's the question?
Yeah,
I'm
what's the
sorry.
So-
On this one?
Dale's question was.
He asked the law department if we should vote yes or no.
Oh, if
Dale,
it's, okay.
can you
got it.
restate your question, Dale?
I-
The question was, is it
Is
hurts
it
the law
cemetery?
department?
Can I speak to that?
Yeah.
Briefly, I'd like to address the provision as it stand in Councilperson Simon's proposed change here. We heard a lot of talk about how this would leave open the option for the prosecutor to take it all back. And I just do not believe that it does that. Based on what is currently in Section A, this is a granting provision. It gives the law director the authority to do this legal work. For example, it was said, oh, if the prosecutor wants to take back labor arbitrations, he can do that. The only way that he could do that is if the county client that is currently having the law department do that chooses to say, I want the prosecutor to do that. He can't unilaterally take it back because now under this new provision, the law director has the authority to do that. So if the executive says, I want labor to be handled by the law department, and they have the authority to do that under the charter, I don't know how the prosecutor could claw that back unless somebody said, we want you to do it. So there would have to be a mutual agreement that, let's say in the future, the executive says, you know, we need assistance with this. We want the prosecutor to step in and help out with this. Then he would do that, but he can't unilaterally say, from now on, you're going to come to me with this because I'm the only person that has the authority to do this under the charter. Now the law director has the authority to do it. So the important part about in D of not having that qualifying language, which was being proposed, by qualifying it, it would take away the authority of the prosecutor. So that would actually limit the prosecutor, which in going into these negotiations, that was kind of our critical point in that we're willing to compromise and put into the charter that the law director has the authority to do this, just to make clear going forward, you know, that the law director's been doing this work and now the charter authorizes it. But nothing from the prosecutor should be taken away by that. And excluding the prosecutor from doing things that he's already authorized to do under general law would take away power from the prosecutor. So that's why we couldn't support that language in the other version.
And I just want to say, this was, especially the last 3 or 4 days, working with Councilwoman Simon, Councilman Sweeney, this was a give and take. And anybody who knows the history of Councilwoman Simon would probably tell you she's historically not been a big fan of the Cuyahoga County Prosecutor's Office. She has advocated strongly for the law department. Everybody knows that. It's not a secret. To suggest that somehow she would fall into an area or accept language that would somehow damage the law department is lunacy. And anybody who knows her knows better than that. And this has been her passion for 2 decades. And we literally had give and take. And, you know, sometimes we gave up, sometimes we got some. It was a natural progression on people sincerely trying to resolve this, and that's what we came to. And nobody would ever say Councilwoman Simon's weighing down on the prosecutor's office, because that never happened. It'd be great if it did.
Chair, that answered my question and then some. Thank you.
Yeah. So, thank you.
Other questions or comments? Councilman Jones, followed by Council President.
Okay. I supported the opportunity for the administration's piece to go forward because it had what the administration wanted, and I thought it was a good negotiation position. Councilwoman Simons, I think, is a little closer to the prosecutor in terms of just what I'm hearing in the room, those who like it and they don't. But Councilwoman Simon made a decision. I'm not a lawyer, but we're all responsible for making this decision, and I'm ready to make a decision. I'm ready to make one today. In these last hour and a half, if there's any conversation that happens that influences what we do, that's great. I just wanted to share with you my thought process about why I did, how I voted the way I did. But again, I'm prepared and ready to vote. If there's any change over this, over the next hour or so, I'm hoping for the best, and I'm ready to support. Again, our colleague has done a tremendous job. I have full confidence in Councilwoman Simon. And again, I'm not saying it's the best of the best, but it's what's before us. And when we make a decision, you make the best decision with the information you have at this moment. And that's the position we're in at this moment. So we'll see what happens in the next hour or so. And we're ready. I'll be ready to cast my vote.
Thank you. Council Vice President.
Since we're working under this document now, can I ask through the chair, even if we move upon moving Councilwoman Simon's amendment out, it still doesn't fully help both sides be in agreement. So I would think it would still be those 3 sticking points that are out there. Would they still be willing to work together if and when we move this out of committee? That's what I need.
Yeah. Let's ask that question directly of the prosecutor and the law director. If we were to advance Councilwoman Simon's amendment, do we feel like we would be able to come to a general consensus or relatively close?
I think the whole document is relatively close. The verbiage on employment matters, I can make a copy. We received an attachment, I guess I got it today from Councilwoman Simon, and we went through, and it was all of their employment issues that I believe somebody from the law department had listed all the issues that they go through. And Nora went through every one and said, here's where that's encompassed in the charter, here's where that's encompassed in the charter, our amendment. And she went through every area that somebody from the law department had listed out. And if your staff wants to make a copy of it, they're certainly welcome to hand it out. But every area that the law department indicated that we do this, this, and this, and we referred right to the charter and says, and that's covered here, and that's covered here, and that's covered here. So we will continue to try to work. I think, like I said, we've been working at this for weeks. What's another hour and a half other than an hour and a half out of my birthday? But what are you going to do?
Happy birthday.
You gonna drop that on us?
And I'm going to the Tribe game I'm going to the Guardians game with my son. What's that? So, yeah, we'll see how it goes.
Thank you, Mr. Prosecutor. Mr. Law Director.
Happy birthday. And of course, we are happy to continue the conversation. These are difficult issues, and they're important. And so, of course, we are happy to continue the conversation as it relates to, for instance, employment matters. Appreciate and respect the review of what we do on the employment matters. I think one of the issues that we will discuss and that we need to discuss in this context is not just whether a specific employment matter is covered under Section B, but whether we are primary, because B says nothing about whether we are primary on that. And so, again, the overarching goal of the law department here has been to draw a circle around our core functions that we have been doing for the last 16 years and protect those functions as being the primary legal representative of these specific areas, not whether they're covered, but whether we are primary on them. So that'll be part of the discussion that we are happy to entertain, for sure.
Wonderful. Thank you so much for that. I just wanted to make a quick comment, if I may. At the outset of this conversation and in discussion of Councilwoman Simon's substitute, it was my understanding that the prosecutor seemed to be very close and that the collaborative piece of that had already been established. And that as he shed light on, it's no secret that Councilwoman Simon wants to protect the law department, right? So I think that's a very reasonable piece. And I was able to review her amendment as recent as last Friday. This one was slid onto my desk, or the dais while we had begun our deliberation. Nothing about that feels good to me with respect to the administration's team. Even having a weekend to review is a hell of a lot better than 5 minutes while my colleagues are chatting. So I think that's deeply problematic in and of itself. So with that being said, I would like to make a motion to move Councilwoman Simon's amendment forward. Do I have a second?
Second.
Right. And Madam Clerk?
Oh,
Discussion.
Mr. President, to my colleagues, I have to confess that I'm kind of in the same position, but opposite-wise. I have not seen Ms. Simon substitute until today. I think that it's pretty close to some of the other drafts that I've seen, but because I didn't see it till it came on my desk, I haven't had a chance to read it because we've been having all this discussion. So I don't know exactly what's in it. I think that the issues of disagreement are too complex and involve too much discussion that it can be resolved between now and 5 o'clock. I think there's a chance that if we hold off, that it could be resolved in time for us to meet the September 4th deadline. We're not talking about an ordinance where if we make a mistake, we can at the next meeting, we can amend it. We're talking about a charter amendment. And I just don't think that we know enough, have enough information. We clearly the sides are not in agreement on some points. I don't recommend that we move it out of committee at this time, and that I think we should just hold it here, and both parties have asserted their willingness to continue talking, and I, for one, am not going to beat ourselves up too much about the fact that this came at the last minute, because the original charter amendment was introduced a couple months ago, and but it's part of the process of negotiations that they usually go to the last minute and until you're up against the deadline before it gets to a resolution. So I'm hoping that can happen, but I think it's too far to go to do it today. So that's my recommendation.
Mr. Chairman, is the council president making a commitment to have a special meeting?
The answer is...
I think I heard that, but I just want you to say it.
Yes, the answer is yes, that
Thank you.
if there's an agreement, I would call a special meeting. Absolutely.
Mr. Chairman.
Council Vice President, then Mr. Kelly.
Okay, so my position is recommendation to move out of the committee. My position was never for them in the next couple of hours to determine, so I want to get that on the record, for them to determine if they were going to agree on 3 major issues that they haven't agreed in 3 weeks. It was just to keep the ball rolling. So I just want to be clear, because I don't want Plain Dealer to quote me wrong, that if we moved it out, that we would be able to have conversation up to September 4th, which is plenty of time. But now the council president is, to my earlier point, is making a statement that we will could possibly have a special meeting.
Mr. Chair.
Kelly and then Mr. Jones.
So we have a motion and a second to move this out. We should vote.
I'm going to have Councilman Jones, and then we're going to call the roll.
When I advocated for time, it was not to kick it down the can. It was simply that we needed to do our due diligence. The 2 parties have already come together and have failed to come to a decision. They've done 97% of the work. It's only 3 points they're differing on. They've had their opportunity, and we need to make the decision. I was only advocating for us to give us the time to make the decision that was not made before. So not kicking the can down the road, just making a decision. And again, Councilwoman Simon has given us what I consider a viable option, If there's any improvement, then I'm certainly all for it, but that's my position.
Council Vice
So
President.
through the chair, to be clear with Councilman Jones Jr., I just want to be clear. So
Appreciate the
what you
junior
just,
part.
yeah, I know, you always
That's
like
how
the
it appears
junior.
on the ballot, you know.
To be clear, in moving forward and getting more time would negate those two. We would make the decision amongst ourselves on these 3 points. I just want to be clear, and we would just leave out the law department and the prosecutor's office. Is that what you stated?
I won't say
just wanna-
leave them out,
Well,
we're
yeah.
counting on everybody to help us, but they've asked us at this point to make a decision.
Okay.
We've got a piece
Based
from-
on those 3 points.
The administration there's some clarity around 3 points. Councilwoman Simon is the piece that's in front of us now and not that piece. But we certainly can't discard the fact that their legislation shows us where the points of contention are. So however that builds into what's in front of us, yeah.
Well, I just wanted to be clear on what you were stating. Okay, if we passed it out.
Any further discussion?
Yes.
Yes, Council President.
I would just point out that if we make it look like we're going to vote tonight regardless, that gives the prosecutor zero incentive to negotiate anything, because currently all 3 of the points of dispute are in the prosecutor's favor. So if there's going to be further discussion between the parties, we have to create the message that we're going to take the time to let that happen.
I think what we'll do is we will call the roll, and I think that individuals' intention to vote it out or otherwise will be the testament of whether or not we're going to continue the conversation. Does that sound fair to my colleagues?
Call it.
Mr. Chair,
Wouldn't necessarily interpret it that way.
Mr. Chair, just for clarification, again, I want to confirm you made the motion. Who seconded?
Kelly?
Thank you. Okay. Calling the roll, Mr. Sweeney,
No.
Mr.
Excuse me, I
Castleberry.
just want to clarify. Back and forth today. I just want to clarify what no means, because we have Sonny's legislation in front of us. No means that we're not moving it out of committee?
Correct.
Okay, I just want to be clear.
Okay. Mr. Castleberry.
I'm going to ask for a point of clarification because
Right.
I wasn't comfortable voting on this because of the time frame it was coming, but putting this out of this committee is going to lead to the vote, or are we still open for more discussion after? That's what I want to know.
Moving this forward would lead to a vote this evening.
Okay, then I'm a no.
Mr. Gallagher. Mr. Schlepper.
Yes.
Ms. Conwell.
I'm confused, I'm sorry. Can we restate what no means? Because the council president wants it to stay, has requested.
Right. Voting no means that it would not advance out of committee.
Okay.
Voting yes would move it forward for a vote this evening, the whole council.
Okay, so since we're trying to be fair and equitable to everyone, all parties, I will vote no.
Mr. Jones.
Yes.
Ms. Turner.
No.
Mr. Hauser.
Yes.
Ms. Simon.
Yes.
Mr. Kelly,
Yes.
Council President Miller.
No.
The motion carries with 5 voting in the affirmative and, I'm sorry, with 6 voting in the affirmative and 5 casting dissenting votes.
Okay. Very good. And I believe that brings the conversation about this charter amendment to a close. I'm going to pass the gavel back to Council President, and we will continue our meeting. Thank you very much.
If we take a break, can people promise it's only 5 minutes? 5-minute break.
So we're at the Rubicon. Do we cross or don't we cross? Do we do something or do we kick it kick that can, as we were discussing previously, down the road? But we are staring at over $40 million in costs that we're going to have to cover. The contract provides for the teams to recover. And I would assume that they're going to pursue that, which is going to put us in a very awkward position. It would be no different than a landlord-tenant dispute, with the law heavily leaning towards the tenants. When I did put this out, I saw that the administration quickly, very quickly, came out and said, oh, it would be horrible, Gallagher doesn't know what he's talking about, and that this would be hurting general fund. Well, actually not really. It's the general fund found money from the 0.25%. But if you want to keep that in the general fund and pay the bills some other way, I am more than open to discussion of any idea that anybody might have. Now, I know the administration went down to Columbus to get a ×4 through the State House and were denied. I think that's what happens when you start messing around with people that have kings to the castle, and in this situation, the keys to your future. And the negative responses from Cuyahoga County to Columbus certainly didn't come in handy, and they were told no. The council wasn't part of that I recall. And I think that would be fool's gold to do that, to ×4 a tax that at ×2 I think would have trouble. And I think a renewal would have trouble in the atmosphere we have today. So this is just an idea, not set in gold, not married to it. And if somebody, especially from the administration, has a better idea, I'm all ears, as we all should be. But right now, what do you want to do? And that's my question to the council. Do we just let this go, or do we discuss moving forward with this plan? And again, I know it's not ideal. I know it's an uncomfortable thing, but what's more uncomfortable to me is borrowing $40 million and paying back $50 million plus just to cover our costs in a short period of time, like we basically just did. So what do we want to do? And I leave it to my colleagues. Please advise.
So, to the sponsor, could you tell us exactly what it does? Is it as simple as it allocates $25 million a year from the 0.25% sales tax to the sports teams, or what exactly does it do?
It would keep everything status quo that we have today, as far as the teams involved and the facilities involved. And going forward, we would have to have, obviously, discussions with the teams regarding this, because, to be quite honest, $25 million isn't enough. It's hard to say that, but the reality that we've been finding, especially with the aging of the facilities, it's just not going to be enough.
So what exactly does the legislation provide?
$25 million a year.
Per year, okay.
For the foreseeable future, meaning as long as the 0.25%'s there, that presents a problem to a future council in 40 years for sure.
Councilman Kelly, followed by Sweeney.
Thank you, Mr. President. So when I first saw this, I'm like, well, there it goes. We had guardrails on that Justice Center Capitol, so that the money that was going into that was used for that in the courts, and then it was removed. Well, the more I thought about it, the more I liked this idea, because at least I know where some of this money is now going, instead of disappearing into the general fund for who knows what. So I would have to say that I would support this. Thank you.
Councilman Sweeney.
Thank you, Mr. President. I just want to share my thoughts on your comments about the team. It's nothing about the teams. It's about Gateway and funding Gateway to meet the obligations of Gateway that was created. So I want to stay focused on that. Every time you bring the entities in, it just gets it all clouded. We have a syntax that was created way a long time ago under previous leaderships of the city of Cleveland. They championed it. They did a wonderful thing to get it downtown. They put the syntax in place, but they made a mistake by not looking to the future and put an escalator in. That's the only reason why we're here today. And I was here for I came a little bit later than Gateway, and I asked Trevor if he'd come up to give us a 101 Gateway, so we have an understanding of the entity that we are not meeting our obligation to fund to meet the obligations of Gateway for the responsibilities that they have. Mr. McAleer, you said you'd come up 2 weeks ago, but I don't know if... And thank you, Mr. Chairman.
Council President Trevor McAleer, County Council staff. I'll be quick considering the time, but
Be thorough.
Well, I'll be quick and thorough, but Gateway, for the council's knowledge, as a reminder, was created in 1990. It was an agreement between the Gateway Development Corporation, City of Cleveland, and Cuyahoga County. What that does, under that agreement, Gateway owns both where the Cleveland Guardians and the Cleveland Cavaliers play, so the arena and the ballpark, and then they lease those facilities to the two teams. The Gateway, as a reminder, is made up of 5 board members, 2 appointed by the city, 2 appointed by the county, and 1 joint appointment, which is the chair. Currently, Debbie Berry and Bryce Sylvester are the 2 county appointments. Gigi Benjamin is the chair, which is the joint appointment. And then Bonnie Tewin is the city appointment. The other city seat is vacant. Under the agreement, as a reminder, Gateway owns the 2 venues. They are responsible for the terms of the lease. They're there to oversee, maintain, operate, and own the facilities. The county and city do not own the facilities. If Gateway were to dissolve or go away, then it opens up a question as well, what happens to those facilities? It gets complicated because the city owns the land under the arena. Arena would revert back to the county and vice versa for the ballpark. So it gets a little complicated. But under the current agreement today, Gateway is the sole responsibility of major capital repairs at the facility. Currently, Syntax has funded the majority of approved Gateway capital repairs that have been funded to date. There have been some general fund monies from the county and the city that have gone towards capital repairs that the Syntax did not fully fund. But clearly, there's been recent stories, and we're having this conversation over the last couple months because the repairs are outpacing the revenue for the Syntax. And nearly all of the Syntax is fully committed for previously approved capital repairs. The Gateway organization, they do receive some revenue from lease payments from the teams, but they use that for current expenses. So they don't have any additional revenue to meet the lease obligations between them and the 2 teams. So historically, those obligations have fallen on both the county and the city. And I think that's what sparked the sponsors' legislation of this ordinance. If I can just clarify, the proposed ordinance, what that does is it takes the 0.25% sales tax that has been discussed over the last couple years and takes basically anything after our debt obligations on the jail and the recently approved agreement with the judges on the court tower. Anything left over that will be deposited into the sports facility fund, which council created almost 10 years ago now. And it would deposit the remaining funds into that fund. If council were to approve this ordinance, then it's authorizing the fiscal officer to distribute equally a third of those funds to the 3 professional sports teams in Cuyahoga County.
Thank you very much. And just a 101, I have no more questions as anybody else has.
Mr. Chair, if I could just add real quick on Gateway. So what happens now is the teams will go to Gateway and ask for capital repairs to be approved by Gateway.
And on that point, the teams aren't asking. It's a third-party validator that assessed the repairs that are needed, and that report is giving to Gateway for consideration to fixing or repairing what is obligated by Gateway. So this isn't the teams asking, this is the third party asking, right?
I was just going to go
Oh,
there,
my
Councilman.
bad.
That's okay. No, Gateway uses a third-party entity that then verifies the request that they get from the team. So they use an independent third-party contractor. So most recently, they got request, and what Gateway will do with their staff, they'll use the third-party entity to go through through those requests to verify, does it meet the definition of a capital repair or major capital repair? So they do use a third party, correct?
Thank you. I have more questions, but I don't have, but Yvonne has a
You
point.
still have the floor.
I think, my colleague, do you have a point?
Yeah, on that, through the chair, Trevor, you talked about 3 teams, but you only said 2.
Yes.
So this ordinance would speak to putting a third, which would, I guess, would be inclusive of the Browns? Wasn't aware of that.
That is correct. The legislation in front of you today, the ordinance, would split the revenue that's deposited in the sports facility fund equally by a third.
So if some of us have a disagreement with that part, we'd have to make an amendment to this ordinance?
If the council agreed to use this revenue source, which is the remaining balance of the 0.25% sales tax, as a source into this sports facility reserve fund, yes, the distribution is included in the ordinance as well.
Thank you. Mr. Chairman, what's the dollar amount currently, if you have it off the top of your head, that the Syntax produces?
I think it's about $14 million annually. I can get you an exact number, but I believe it's about close to $14 million on an annual basis.
And it's been going down over time because of the lack of
Correct.
sin that is being
Yes.
committed. So, and 14's not chump change, but it's nowhere near the level of dollars to be able to meet the needs of
No,
the
and
responsibilities of Gateway.
the Gateway teams, right, they have a multi-year forecast, which in the past has proven fairly accurate of the need that will be needed over the next 5, 10, 15, 20 years. And just now through 2034, the Rocket Arena, it's estimated that they're going to need about $140 million worth of repairs. Progressive Field from now till 2036, I believe, is about $149 million. So over close to $300 million of repairs projected to be over the next decade.
Thank you. This is a real situation that has to be dealt with. We've kicked the can down the road way too much. This is something that has to be really focused on, and I hope as we focus on it and come up with a solution by the end of the year. So thank you, Trevor. Mr. Chairman, may I continue?
Yes, you may.
Thank you. Debbie Berry's not going to like this, but being our board member, can you just tell us a little bit from your perspective as a board member about Gateway? Without too much details, what is it like?
What are you asking specifically, Councilman?
You're on the board. You heard what the.
Hold on. Could you please come up to the microphone and
The other one,
put your name into the record?
Debbie Berry, Chief of Integrated Development, and also in this role as a board member for the Gateway Board.
Yeah, and through the chair to my coworker and Gateway Board member appointee, what's happening there? I mean, as a board member, how dire it is, what solutions are you working for? Very lightly, because you were sitting there and you mentioned, so I wouldn't mind
Sure,
your perspective.
absolutely. So, I mean, as Trevor said, when Gateway was originally put in place with the funding mechanism being only the sin tax, no one ever thought to mark that for inflation. So we're getting the same amount or less amount, as you heard, than we have been, for the last 20 years. Of course, the two facilities are getting older. There's more funding required to keep them up. One of them sits outdoors, so deals with weather and all those other issues, in addition to just modernization and other improvements that are naturally going to happen over 20, 30, 40, 50 years. So we absolutely know that we do not have enough funding available with this one source to cover all of the expenses to maintain those two facilities. We do believe that through the end of this calendar year, we should be able to fund all the existing approved projects to date, but some projects were introduced at the last board meeting that would look to be approved at a September meeting potentially of the board, and there is not enough funding available to cover those requests going forward. So we have been meeting the administration with the city, with the teams, have looked at multiple different solutions. Unfortunately, at the moment, none of those have come to pass to be able to add to the funding. And so we don't have a viable solution on the table at this moment, but we continue to work towards that, and we continue to be good partners with the teams and the city to try to figure out, what solution is going to work going forward.
And thank you. It's Gateway's part of the discussions, though, because we have the county, the city, and the Gateway entity all working together. And would you say there's a significant time crunch, focus, all hands on deck moment right now?
To the chair, to the councilman, I would say yes. Again, as we get towards the end of this calendar year, we're going to have new requests and do have new requests coming in that we Gateway likely cannot fund with current sources.
Okay, thanks for letting me cold cock and getting up here, but you did help in my discussions on this piece of legislation. And I appreciate through the Chairman Gallagher's drive on this. All I look at this as is another funding option that is available to satisfy the obligations of Gateway. This is a 25%. It's going to significantly impact the budget. Syntax, are we going to do that? Is there another revenue stream? So I am going to be focused on this. I know the council president's focused on this. I know the city of Cleveland's focused on this. I know the two facilities are focused on this. But we got to make a decision, and none of them are easy. And once again, I want to commend my chairman for focusing on this, and I look forward to seeing where this goes, but it really needs to be an option for the funding stream. Thank you.
So, Councilman Gallagher.
And again, this is to kick off discussion. If somebody has a better idea, is it a ×2 with an escalator, as Mr. Sweeney said? Maybe that gets us there. My concern is that we're going to end up borrowing money and paying the ransom of borrowing money. And we can't continue to do that. So if someone has a better idea, I'd be more than happy to withdraw this and go with whatever someone has. I haven't heard anything that I think makes sense. And I can see the flaws in this, quite honestly, because we're taking money that we would hope would be put to a better use. But our backs are against the wall, and we're kind of used to that, Mr. President.
So on that point, the Director P reported that after various obligations are factored in for this year, the county is projected to spend $28,256,791, the remaining amount after other obligations for general fund expenses, of which 71.7% is public safety related, sheriff, courts, medical examiner, public defender, prosecutor, et cetera, et cetera. So the question is how do we squeeze $25 million out of the general fund expenditures to make the money available to do what's being proposed here?
Well, again, it's going to have to be massaged, knowing full well that at the beginning, as we have costs coming in on the jail and the agreement with the judges, that the money right up front is really not going to be there, that we totally need. It's why I've always said that this is a discussion. This is a potential way to start it. It is not going to be enough to pay our bills, and it's going to have to be a Part B. And maybe the Part B is an extension of the 0.25%, as is with an escalator, ×2 with an escalator. I think anything more than that, you're walking down an alley in the dark. I think the taxpayers have pretty much had it with us with taxes, and we've got to come to a solution. So this is a partial solution, and again, it kind of hurts to do it, but no matter what we do, it's going to hurt to do it. Because in the end, if we don't pay our bills, if Gateway goes under, then that does become ours. That's our problem. And we also have partners here that are fronting money that they expect to be paid back. And that's happened time and time and time in the past. We have, and I will say this, our partners have been pretty good, especially the Cavaliers. They added money to the facility that they didn't have to add. It was rather large amount of money that they added after we agreed to pay. I believe it was 90 million, and he added another 50, 60 million. It was a lot of money. So we have good partners who are depending on us to come up with a solution. I'll be the first to tell you, this isn't the full solution, and it might not be even a start for some people, as I've already heard because of the Browns being in it. But keep in mind, in 16, when we added Cleveland and the stadium, it was pretty much a big favor to Cleveland. Now we're going to have that team in Brook Park, who's also, and I remind everybody, is still part of Cuyahoga County. And I've talked to all three teams, and they all seem to be under the impression that if we did come up with a solution, the Browns would sit it out for X amount of years because they have the newer of the facilities. The worst thing I think that could happen is these things fall into disrepair. We don't pay our bills. They become on our books. And now we're looking at a potential of one of our partners deciding maybe the grass is greener on the other side somewhere. And I think that's happened once before, different circumstances, but it happened. It can happen. Cities are out there massaging all the professional teams now. And I'm not going to say that our partners are going to do that, but it's a reality. And I think they're looking to us and the administration to come up with a solution here. And if it is, maybe we go down in Columbus and ask for it ×3, then so be it, if that's what everybody agrees to. Would that pay the bill? Probably. Be a little bit low, but probably would get us closer to where we're at right now, because where we're at right now isn't doing it. So I'm open to anything.
Any other questions or comments, Ms. Turner?
Thank you, through the chair. I'm wondering, does the Office of Budget and Management have a projected idea of how much money annually will go to Gateway after the jail and the, what is it called?
Courthouse.
No, not the
The court
courthouse.
agreement.
The court agreement and the.
Yes.
Yeah.
That's going to come in just over,
I think it's 14 or something.
yeah, just over $1 billion. But the 0.25% over the 40 years. And again, it fluctuates because we don't know the economy at the time. But if it stays even at 2% right now, that's going to be well over $3 billion over the 30-year or 40-year period.
Through the chair to the councilwoman, I do not have that number right now, but I could calculate that,
Okay.
Generally, we've been using a 3% factor on sales taxes for the outgoing years. We've been running pretty solid on that, so I can take the debts off, just as Councilman Miller explained, generally it's about $27 million right now is what we're spending on operations out of the 0.25%. But I could do a calculation for you in the future when all those debts fall off and.
Other questions or comments? Councilor
Very
Sweeney.
briefly, you made this statement after you listed all the different offices or departments that are part of the decision to where this money comes from. It boils, because you brought it up to me a few times. Are you going to be able to, should we do this, should we do that? It's just tough decisions that need to be made by this council because we're all here. Is a tough decision going to be there? And if this goes this way, there are absolutely tough decisions with this administration, with us. That's the reality that answers the question that you posed to Mr. Gallagher. I thought I'd share that with you.
And Mr. President, I would also admit that the earlier years on this are going to be problematic, which is why I think we need another way in which to carry ourselves through the tough times, which are going to be definitely the first 5, 6, 7, 8 years.
Okay, so if there's no objection, we're going to consider this a first hearing and one option as part of a potential solution to a very serious problem that we all have to deal with. And for now, we'll hold it in committee.
Thank you for your leadership.
Okay. Next item is ordinance 2026-0005.
Ordinance 2026-0005, accepting parking rates for all county-owned and leased garages and surface lots, effective September 1st, 2026. Authorizing the Director of Public Works to set rates for county-owned or leased parking facilities effective September 1st, 2026, and to revise existing rates no more frequently than once every 2 years upon approval of this Administrative Rules Board, repealing Resolution 2016-008, adopted January 26, 2016.
Good morning, good afternoon, Mr. Chairman. Michael Dever, Director of Public Works, along with Nicole English with Public Works also. We're here to present this legislation, and we'll jump right into it in the interest of time.
We have a presentation that's coming up. Hopefully you guys have that in your hands too, copies of it, correct? You don't? Oh. Joe had the paper. Joe had the copies he was going to hand out, and he's not there. Do you want us to do it? Joe said, okay. Mike is getting the copies. We'll quickly just go through the basis for increase of the parking rates. As you heard previously, 2016 is when we last increased the rates. They were in March of 2016. There was a parking study that we did in late 2019, early 2020 that we were going to bring forward, but due to COVID, that parking rate adjustment was sort of shelved at the time until we figured out what was happening with COVID. And then the new administration came in and we took a little while to get back to this. And so in late 24, we talked to a consultant to relook at a parking study, and they gave us their draft recommendations in 2025, and we've now presented this moving forward. So we've also acquired additional lots. As you know, through your approval, we purchased a couple parking facilities by Virgil Brown so that we had control of parking around the county building. So that was to the tune of almost $5 million. And then also we have increased maintenance costs for the current garages and lots that we already own, and then creating consistencies across the county where there are some places where employees do pay, some where they don't pay, some where people pay more, some where there's not available parking. So trying to create a little bit more consistency across the board.
So, Ms. Nicole?
Yes.
Okay. You weren't advancing on the screen.
Sorry. So The 2025 parking study, as I talked about, we used a general engineering services contract that we had in place, who was HNTB, who performed the study. They looked at parking rates by zones in our buildings and available market parking and made recommendations that we then took into consideration. We looked at these in zones, so we've grouped buildings together that we would consider similar in nature. And so the first zone that we looked at is the Justice Center zone. So as you can see, the Justice Center tower or complex in the middle, there is several garages under that building. We refer to them as the Judge's Garage, Tower 2 under the Cleveland Police Headquarters, and the Sheriff's Garage. Where the old courthouse is, we of course own Huntington Park Garage to the north of that building. And then at Courthouse Square, we own two smaller lots, what we call Courthouse Square lot and the Summit lot to the north of those buildings. Currently, the parking in the garages is 105 for county employees, although the sheriff's garage is not charged right now, and judges pay $50 per agreement. And then in the lots, Summit lot and Courthouse Square, that's an $85 a month charge. So there's also a private rate in Huntington Park Garage, which is $200, and that is only for, the only people we provide parking to that are not county employees is, on a monthly basis, is the Hilton, and that is per the a management agreement we have with the Hilton. So they pay that premium rate for their reserved parking in the garage. I just want to note, back on, well, maybe we won't go back, but just to note, there is more employees than parking, even in the Justice Center zone. So we've gotten several questions about, are there more passes available? Not quite at this time. When Cleveland moves out of Cleveland Police Headquarters, there will be a floor of parking there that will be available. But we do not have enough parking in this zone so that every employee, if they wanted it, could park monthly. Daily rates in that area, I don't know why this won't go back. Oh, there we go. Daily rates in the area, I didn't hit on that. The only place that you can pay daily right now is in Huntington Park Garage. We do reserve some of those spots for jurors, people coming to court. So we've had to be really flexible and creative in trying to reserve some of those spaces, because when, for example, Sherwin-Williams was being built, as we know, the trades folks typically start quite early compared to maybe our employees, and so they were filling up our garage because the price, our daily price, is significantly lower than the market surrounding us. So that's why we've looked at sort of the rates and trying to be competitive so that we don't necessarily be the most attractive in town, so everyone's filling our garage first, which leaves no spots left for people trying to go to court. The next zone is the Virgil Brown 1801 zone. So this area is surrounding our current buildings. We bought last year, like I talked about earlier, County Lot 1 and County Lot 2. Those were for a little bit under $5 million plus closing costs. And we lease the 1801 garage and lot. So note that currently there's not been charges in 1801 since they moved in, so no one has been charged to pay there. However, the Virgil Brown lots have been managed by a private company prior to us buying the lots and currently, and so employees that work in Virgil Brown have been paying as long as they've been there in the private area. So you can see the surrounding lots. This zone does have a lot of extra parking as far as private lots go, and so there is a lot of options for employees in this area. The extra lines on this, I know this is a really busy graphic, are really a 3, a 5, and a 7-minute walk, because there was some discussion as far as, how long would it take to walk to additional parking if an employee did not want to park in a county lot? So that's just giving you some perspective there. To be clear, at 1801, the surface lots, which one is where the grassy area was, which we converted to an ADA lot. The other lot to the north would remain for visitors. Anyone coming to that building, they would not be charged to just be a visitor. If you wanted to vote, in-person voting, if you needed to file your petition at the Board of Elections, that would not be a charge to you. It would be the daily and monthly employees that are parking there for the whole day that would receive this rate. The next zone is what we're calling East 40th Zone. So these are the buildings of J. Ned Hunter and the Halley Building, which we control. We own 2 lots, Perkins and Chester in the blue there. And then the other 3 lots in yellow are leased lots. So the issue we're having near J. Ned Hunter, we also own the J. Ned Hunter lot just to the north of the building. Sorry about that. The lease lots, we have been put on notice that they are planning to start developing these lots, starting with the flag-shaped lot of Premier Lot 2. And so this sort of flag area, the square part of it, is the first where they would take development and start moving down. So we are going to continue to lose parking in this area. And so this idea is that the market is not as high as the downtown zone, so you'll see when we make recommendations that this is a lower charge because of this area and what's surrounding it. However, we are going to have a lack of parking moving forward as these lease lots get developed. The next is the medical examiner building, Samuel Gerber. So this is a garage that we have to maintain, and we are currently in the process of analyzing the needs of the garage, but we know there are a decent amount of repairs that are needed in this garage that we haven't done work on in quite some time. They currently are not paying in this garage and have not. However, if you see the market around, it's fairly high if you can even find parking in other places. Most of University Circle, if you try to go to the clinic or otherwise, you're paying to park there. And so we see that there is a market in this area for parking, and we have the need for the garage repairs. This is just to show you, because the juvenile court is in the legislation. We're not proposing an increase here, but for as long as juvenile court has been open, there are two lots that we own, the public lot to the north, the private lot to the west, and there's a small garage underneath the Justice Center, which mostly judges and employees park at. They have been paying to park as long as this has been open. We are recommending that we match their parking rate for that East 40th zone. We see these as somewhat similar, a little bit outside of the central business district, and limited in other parking that you can get, but would explain, sort of, we still have to maintain the lots. We have to provide security gates and those type of things for these lots. So I'm doing this fast. If you have questions after, we'll go back to it. I just am trying to be respectful of your time. The recommendations that we're making is generally increasing daily parking at the Justice Center zone by $2 a day, so going from $10 to $12 per day, and then raising the monthly rates by $20 in those areas. Again, you can see the employee rate at the 105 going to 125. The 200 is that Hilton rate going to 220. Courthouse Square, again, going up $20 from 85 to 105. Virgil Brown, currently those two lots that are being charged, the ones we own but are being run by the private company, are charging 85 and 100. We're recommending those go to 90. In the same zone as 1801, 1803 would also be 90 per month. And then $40 is the East 40th surface lots, similar to like we talked about the juvenile court lot. And then $100 for the medical examiner's building, but it is a recommendation to tier those ones since they pay nothing now and are going up to $100 at a tier of $50 year one, 75 year two, and then get up to the $100 on year three. So those are the main recommendations that we are making on each of those lots. There's a couple additional data charts that we have here that was some questions that we got from council that we wanted to answer. There was questions about how many monthly passes we currently have. You'll see in Huntington Park, that's the county monthly plus what we lease to the Hilton. The Justice Center Tower 1 is the county plus what Cleveland gets per their lease. And then the rest of them are county employee monthlies. You can see the current monthly pass revenue that we're making, and then with the revisions that we make, with a couple estimates, because we don't know how many people will take us up on the offer for a monthly pass versus paying daily on the buildings that we currently aren't charging. But it goes up by about $90,000 a month. So that's what we would increase our revenue monthly. And you ask why. So the why is we currently have a balance in the parking fund of a little over $5 million. This is an enterprise fund that is kept separate from the general fund and used for just these uses. So we have $5 million. Last year we took in a little over $3.7 million. However, our annual expenses are over $4 million. So you see we're going down if we keep eroding at the current balance. You can see some of the high costs. We did a project on Huntington Park Garage many years ago for about $21 million. We have debt service paying that back to the general fund. That's a big one. And then We do have a staff of 4 that works. There's payroll costs, addition when the Browns play. We have extra costs to clean the garage and make sure it's ready to go for the week. Then here's the recent capital investment. So you might say, well, you're close to what you take in and you had $5 million sitting in the bank. However, we've spent over $8 million in recent capital improvements. This is from 24 to 26. That's a big chunk of that was the purchase of those Virgil Brown lots. And then you can see other improvements that were made to Huntington Park Garage and some of the surface lots. Then it keeps coming. Like we just heard about Gateway and increased costs, we are also seeing increased costs on these structures. The garages cost us the most. However, the lots, we do still have to resurface, stripe, maintain equipment that gets hit. But in general, really it is parking garages that are taking up a lot of our funds. And so you can see these are images, recent images of underneath the Justice Center where you have shoring. Again, when you're shoring up spots, you then can't have anyone parking in the spot. So now you're bringing less revenue in as well. So it's kind of a vicious cycle. Also the photo of the lot, that's one of the Virgil Brown lots that we bought. And then the bottom right is the medical examiner's garage there. I do want to just say we understand that this is difficult legislation. We've looked at other options that we can present to employees to try to help them, you know, if this increase is too much. There are RTA passes. The county deeply subsidizes RTA passes. Most of these buildings, even including the medical examiner out in University Circle, are serviced by the RTA. If that could make it work. There's also a Go Ohio commute option where you can search for carpooling, and you can even search by employees of the county. If you want to match with employees of the county, you can match with people in your building, you can match with people in a certain area. So we have looked at other options to try to provide some relief for employees that perhaps, you know, don't want to rely on parking at the county lots. So I ran through this really quickly. We have talked to many of you and tried to address some of the concerns we got, but happy to answer any further questions.
Questions by council members? Yes, Councilman Hauser.
Through the chair to Nicole, I appreciate us going over this together weeks ago. It's always helpful when we don't get it right before the meeting. I do have 2 main questions. One question, Nicole, why as the county are we paying for garages that we're leasing, and are we doing anything proactively to try to get us out of those type of situations?
So the one situation that we're in with that is 1801, 1803, and that was part of the lease. So they did invest a large portion of funds up front, the landlord, in order to get the garage to a level that was acceptable now. However, moving forward as part of the lease, we are responsible since we are the ones who requested that the garage is part of the program in that building. So I would say that's the only one.
It was important for us to get enough parking at that building for an election cycle specifically. So that was one of the key reasons for keeping the garage in place, making the investments as part of the 1801 agreement. So, but going forward after that initial investment, it falls back on the county to maintain that garage going forward.
Is it, just a follow-up on that, is that a forever lease or?
No, that's just for that facility.
Okay, will the county be paying?
It's the 15 years
15
that the
years?
lease that we're into.
Thank you. And then my last question, Nicole, during our conversation, you highlighted that if you guys aren't able to get funding, you'd have to go into the general funding. Please say this publicly on the record, because I think it's important that everybody's aware.
Correct. I mean, that's based on our chart that shows you how much the parking fund has and then our upcoming need. If we don't bring it into the parking fund, from the parking fund, we will have to ask the general fund to help us with that, with those improvements. We have no other funds for that.
And go into the consequences that you explained to me, from furloughs to different.
So we would leave it up to OBM, but I mean, that's the idea is at some point, how do you get more money from the general fund? And so there could be other impacts on employees. We've looked at it as this smaller increase in monthly parking is better than not being able to fill positions or, like you said, extreme conditions. Now, I don't know if that still will have to happen. I'm not the budget director. But the idea is that we are trying to fill it this way so that we don't have to ask for other cuts in other ways to fill the parking fund.
Thank you.
Councilman Sweeney.
Thank you, Mr. Chairman. Co-workers, how are you?
Great.
things come to my mind when you answer questions, so I always advise not answering too many questions, be as short as possible. But you just mentioned furloughs and these numbers don't add up to people being laid off and furloughs by the entire county. Those are very large numbers, right? It's like $14 million for everybody to, furlough. There's serious ramifications, but I don't think it raises immediately to Armageddon for our budget.
Yeah, I think the point just being made is that we're going to need millions of dollars to invest in these garages and keep them open. We just mentioned about the Gateway Stadium.
Yeah.
About the investments. That's an open-air stadium, very similar to all of these garages, so the investment. So our concern is that then we're going to need to direct towards the general fund, which needs to take care of the buildings also.
No, absolutely, but I just wanted to, in my mind, the way that my colleague, Chairman
Yeah, because you told
Hauser.
me, because you said furloughs in our meeting, so please, Councilman.
Yeah, what dollar amount would have to come from the general fund?
It is millions a year that we need. So we will be short. We only have 5 million. We have, how much this is just the near-term capital is over 8 million. We only take in less than 4 a year, so you add that up over time. I mean, it is millions per year that we will need
And the
going
worst
forward.
case scenario is 4 million per year with your math.
Sure.
Is there, through the chair, any option of closing down any garages and make the people park other places? Because they're so bad and we can't afford it as a different
I mean,
option
that is
instead
a-
of tapping in the general fund?
It's a different option, but I can't imagine that the Justice Center would
No, I'm not
feel-
talking about the ones that are impossible, no, but I'm just trying to, what you have right now through the chair is there's no other funding stream except the general fund. And I haven't thought it through, because we did sit down, and I appreciate it, and we'll get to that portion in a second, but I'm just responding to the answers that the question that my colleague asked into your answer.
There is no other funding that's available for this besides the general fund.
Okay, there's no, I'm just, grants that can be for the issue 2 or
No.
all that other stuff, federal help and all that stuff, so it's.
Not that I'm aware of.
No, and all our road and bridge funding has to be spent on actual roads, not private garages or
It's-
lots. So we
and-
do not have access.
Got it, and what we talked about was the impact on our coworkers, and some are not paying at all. And through the chair, just being a smart aleck, is the administration interested in supplementing their pay to raise their money a little bit so they can pay for this?
That's not part of this proposal at all.
Okay, I was just curious. And with the, we talked about the tiered approach, but too specific, because we hear it from all our constituents and our coworkers. With the medical examiner's building, and Nicole mentioned that it's in University Circle, but through the chair, it's just in the middle of nowhere of University Circle, from my perspective, of distance where they would park to go walk to the art museum or walk to wherever, so in that area. And with the medical examiner, it's my understanding that the gate, they don't let people in because of certain criteria met with so this is just strictly for the employees?
No, there's enough parking there for it to be open to the general public also. And our intent is to put the appropriate gates in place so that it is available for others to use. It's not fully utilized.
Yeah, and through the chair, is the medical examiner okay with that in regards to their protocols? I mean, we can't have somebody parking here because we have the sensitive stuff going on in our building. Is that a thing?
In regards to sensitive, I mean, they're not going into the building per se, okay? They're in the parking garage outside, much like people are going down to the Board of Elections into the parking garage. So they're not going into the building itself.
Got it. Because you hear.
Had conversations with the medical examiner and his administrator. They're generally not supportive.
Oh, yeah, we know that. That's why we have to
But
balance
we did
them.
work out an arrangement with them, and that's why you see this tier option that's presented, so it's less of an impact to those employees.
And through the chair, and we talked about tiers for other folks as well. Just with the Board of Elections, it just seems like the 40,000 just jumps out at me as a number more than all the others. That's just because there's more people that'll be utilizing it. 1801, third last down.
Yeah, I think that was assuming most of the employees purchase a monthly pass. I mean, we didn't figure out how many would come daily and switch. So that number could be a little bit inflated. That's why I show it as estimated. But I do want to note that those employees that used to be in the Hughes building down the street, they were paying $40 a month. So they were paying to park. It is going from 40 to 90, so there's an increase there. But they've also had the last 18 months not paying at all, while we were still getting the garage in order and the building wasn't fully staffed. So they have gotten a little bit of relief also over the,
And through the chair, I'm not going to give any credit for them getting freebies, because that's just.
trying to put the facts out there, yeah.
Oh, I appreciate it, but just in my own deduction. So you want this to pass today, but we talked about tiers for other folks. Do you have any recommendation for the folks that were going from 0 to 90 or
40 to 90.
40 to 90? Or, yeah, if there's a,
Seeing that this is one of the newer garages, I mean.
no, just, you have like 10, what is it?
Yeah,
1, 2, 3, 4, 5, 6, 7, 8, 9.
Obviously, the administration, we'd like to move forward with this, understanding if council needs to continue to deliberate about it. And we're open to suggestions. I guess the point I'm trying to make is we have a need that is going to need to be addressed. And so if it needs to be spread out over some time, we can understand if that's the approach council would like to take.
Yeah, and we talked about it. I'm all into a tiered, and, first 2 years, first 1 year, but that all has to be discussed, and I didn't take the time to reach out to continue the dialogue, so I apologize for that. But I look forward to a deeper working opportunity with your department to come up with some kind of tiered, and nobody wants to pay more. We know that. And there's a reality that we need to take care of our garages, and we know that. So we have to make the decision through the chair on what we want to allow you to charge. And I want to continue the dialogue on the tiers, because if it doesn't come out today, we jump right back on it in September, and I'll make a commitment we'll have it figured out by then for my vote.
So I think, what was suggested during those discussions was specifically the garage that's at the 1801, 1803 facility as the potential for, Mr. Chairman, I'm sorry, Mr. President.
Go ahead.
So I think there's a suggestion that that specific garage, that be looked at as a tiered approach also.
I'd like them all looked at, but that's one we talked about.
Yeah. So.
Other questions or comments?
You cut me off?
I'm sorry.
Okay, I'm going to give it to you.
I thought you were done. Continue.
I think what we would suggest is we could look at a tier for that one that would start at 50, 70, 90, do a similar tier like we are doing for the medical examiner building. I think the other garages have already been paying, they're going up slightly, so I don't see that tier being super helpful.
Perfect.
I think for the one that is
Is new.
new and going up more, it could make sense. And it would be in line with what we're doing at the medical examiner.
Okay, well, I think that Councilman Sweeney expressed what a lot of us are thinking, and that we recognize the need, but the final version might look a little bit different than this, and we're going to take the time over the recess to do more work on this and try to come up with something. And if there's no objection, I would like to hold this in committee for that time. Hearing none, that will be our action. We have 2 remaining items that should be fairly quick. They're just discussion items, and the first one is the briefing about the item on the temporary extension of the Metro Health contract on the jail. Do we have someone from the administration to speak on that? Good afternoon, Mr. Sheriff. Welcome.
Good afternoon. Thank you, Mr. President. Ladies and gentlemen of the council, just want to thank you for your support and everything else that we do. But today, just really quick, the Metro extension, you know that we're currently in contract negotiations going through that. And we just saw that we were almost out of money there. So we need a very short extension to get us to the finish line. We're finalizing some final points, changing happy to glad and those sorts of things. So we have Metro representatives here. Chief Rivera works very closely with Chief Bellamy on a regular basis and members of her staff at the Metro Hospital to ensure that we're doing everything right, we're getting things correct in the contract. Our legal team, headed by Greg Huth, is working almost daily on this to make sure we get it, but we do need this short extension to get us over the finish line, sir. And I know Chief has some more of the specifics for you, if you have any more questions.
Please continue.
Good evening. Nestor Rivera, Chief over Corrections. So as the sheriff stated, we continue to negotiate. We've had some challenges due to vacations, things of that nature, but we are very, very close. We feel comfortable, and Mr. Huth has been working diligently to assist along with the attorneys from Metro. So we're close. We just need a little more time.
So the contract is for $4 million. It goes through October 31st, 2025. The idea is that we'd have a full contract ready for introduction in September, but if it went 3 readings, that would take us into early October. So this allows the time for a full discussion on the full contract. So the temporary contract is going to be up for passage tonight on first reading suspension. I do encourage support for it. Are there any other questions? Hearing none, thank you very much. We appreciate all the work you're doing to bring this to the finish line.
Thanks, Mr. President.
Thank you, Council.
Yes, okay.
Not about this. I just want to congratulate the Sheriff's Department on that large narcotics arrest. Thank you for getting that stuff off the streets.
Thank you, sir. Very important to have the right people doing the right work, and they're out there doing it every day. So it's the men and women of the Sheriff's Department who are out there beating the pavement every day. I appreciate their hard efforts to work for all of us and make it a safer county.
Okay, thank you.
Could you add my name to legislation?
Yes. Please add the council person's name for the item for tonight. Thank you. Final item is we're going to have a short briefing from Director P on the numbers related to the HHS levy and an opportunity for any final questions before we vote on that very important question at tonight's meeting.
Good afternoon again. Walter Parfiowitz from the Budget Office. Janine's going to pass those schedules out, but basically I'm here to explain the difference in the 2026 HHS levy ending cash balance from first quarter to what was presented at the last Committee of the Whole, and now that we have a preliminary second quarter number, I'll go all the way through the entire schedule. The schedule was emailed out, I think, last week, but Janine's going to pass it out just in case you don't have it. So looking at the schedule from left to right, there's 3 boxes. The first box, you see it's labeled there. That's where we ended in the levy fund after first quarter. You see down at the bottom, the ending cash balance was $2,899,518. I believe, the $3 million that Councilwoman Simon was referencing. Box 2 is basically that's the adjustment that I put through when I was doing the projections for the levies, and it's Resolution 2026-0119. It was adjusted to Children and Family Services to reflect $7,319,698. That's the levy portion of what was approved by council for child welfare provider rate increases, so that reduced the projected ending cash balance at that point in time down to the negative $4,420,180. So that's the number I think that everyone saw on the graphs and charts at the committee of the whole. Now, taking one step further now that we have some preliminary numbers for second quarter, I presented these at the Finance and Budgeting Committee last Monday. So now we're projecting ending cash balance of, again, positive $3,170,083. So you can see that there includes some revenue, $3,871,767. This is all from the tax lien sale. And reduced projected expenses now in the levy of $3,718,486, leaving us with an ending cash balance of $3,170,083. The adjustment that was put through, I put it into the projections that were in the graphs and charts that you saw previously. For me not to include those in the projections going out for the next 10 years for the levy would have been inappropriate. I hope this clarifies the differences. You know, it's, but I'm happy to answer any questions.
Any questions? Councilman Sweeney.
Thank you. I just want to thank you, Walter.
Oh, thank you,
For all
Councilman.
your
I
hard work.
appreciate your comments.
You know, you have a tough job, and to report to all of us, and you're the gold standard for us.
Thank
so
you.
Thank you.
So, Director, could you clarify, what's the difference between the first column and the second column? What do those two reflect?
To Councilman Miller, the first column is the first quarter budget update. So those were the numbers that I projected at the first quarter Finance and Budgeting Committee when I presented on the results. The middle column are the numbers that I presented, or I think David Merriman actually presented the schedule. The second column there is what was presented for 2026. You see the negative ending cash balance at the bottom, $4,420,180. That was on a schedule and on a graph that
So the second column is later information
Oh,
than
yeah,
the
it
first
was,
column.
it was all a timing thing
Right,
here.
okay.
Councilman, just between first quarter, second quarter. And I made an adjustment because I knew of a resolution that was approved that added expense. So I decided to put it into the projection going forward.
Okay, thank you.
You're welcome.
Any other questions or comments about this chart or anything else regarding the HHS levy? Councilman Sweeney.
Thank you. I don't need Walter. Thank you, Walter. We just heard the numbers, right? And the incredibly important reality that this HH levy needs to pass. We're 92 days from Election Day. Can you tell me what plans we have to get this passed? I mean, I want to play a role. I don't know anything about what's happening, who's the face of it, if it's not the appropriate time to talk about it, I'll let you off the hook. But I want to drive home we know the reality of the numbers. We don't know the reality of how we're going to get it passed by the voters. And I think we're way behind schedule. And we know all the oxygen, because we're all decent, I can't say I am, but in regards to elections and getting things across the finish line. And all the oxygen is going to be taken out with a contentious Senate race, a contentious governor's race, and a contentious race for Congress in the 7th District that's some of us are participating in. So has there been discussions on how we're going to do it and all that stuff? So the general public needs to hear this too.
So the answer is that anticipating that what we think is going to happen tonight with the passage of the levy to put it on the ballot, there's been preliminary work done, and there's been some campaign resources identified. There's been some fundraising done, and There's been some polling done, so some groundwork has been laid. Are we behind where we've often been, as you suggested? Yes, we are, but we're not starting at zero, and I think that we're going to be able to put a campaign together and take the message to the people as to why this is important, and I think each of us hopefully can play a part in that.
Absolutely, and I have all the faith and confidence in you, but us and some of the distractions that we've been, that have been promoted in the media doesn't help at all. And limiting those distractions, and if there's distractions out there, that we need to take those into consideration on how we move forward and limit the losing the word, openness to criticizing and leaving some folks on the side as we move forward would be my thought. And I'm trying to be very careful, and I'm not delivering the message I want, but we'll talk about it later.
Okay, sounds good. Anything else? Okay, is there any miscellaneous business? Hearing none, the committee of the whole stands adjourned. Thank you very much, everybody, and the council meeting will